Sorry, we have to sit at courtroom number 4 to deliver certain judgments.
My lord,
Yes.
May I be permitted to mention one review application for inclusion?
Can't hear you.
But may I be permitted to mention one review application for inclusion in your lordship?
Our order,
Lordship,
Yeah.
2nd of February order.
whatever, gave.
my lord, may I have my lord's kind leave to mention a matter? My lord, I'm praying for leave to file the vakalatnama and file the vacating application. The reason I require leave is there is an error in the cost title of the appeal which they have filed. And the name of private limited has not been included, so the department is not accepting. The description by the plaintiff is incorrect. So that is why, without the leave of my lord, I cannot, it cannot be filed.
But
That
if
is
the,
fine.
if the private limited company is not a party, then what to do?
No, the defendant is creams, cakes and bakes. That's the only thing. So it doesn't describe whether it's a partnership, private limited or anything. But it is a private limited and that company is now filing the vakalatnama.
Let the
Your
matter,
lordship has been pleased to pass an injunction.
let
But
the-
that company is not a party otherwise. Because in the cost title, the description is not there. So I cannot file the,
let the matter which my lordship is mentioning is appearing as item number 1 in my lord's appellate side list today. And with regards to this private limited being omitted from the cost title, we had mentioned it before the judge the honorable judge who had taken the matter and passed an injunction, and the leave was granted to correct it. So that I've just find out from my advocate record whether the correction was made or not. But the matter is appearing.
it's
that
not,
he can
department is
address-
not accepting. We had gone to file the vacating.
Correct.
Matter is
Now,
there
yes.
today. The matter is there today.
There,
He can,
it says that it is the correction has been directed. If the correction has been made, then there is no difficulty.
but I'll just
Correction
find out
has
from my
not been
advocate
made.
record.
Correction has not been made. It's not permitted to be filed. Correction has not been
The
made.
matter is there in the list today before my lords in the appellate side, item number 1. We will sort it out then, madam.
Come
My
on
lord,
that day, come when the matter is taken up,
Correct.
we will consider it.
Right.
Don't worry.
Lorships, may I be permitted to mention an appellate side matter, commercial matter, Lordships? This is in section 37 appeal. Which may be included. Paper books are ready.
Let us see.
Permitted to mention, my lord, I'm praying for leave to file the appeal without certificate copy of the order, my lord.
When the order is passed,
My order is 3rd April 2023.
have you applied for certified copy?
Yes, my lord, I applied on 4th April, my lord.
Have you annexed the copy of the certified copy?
Yes, my lord, yes. Xerox certified I have applied.
No,
Xerox
no.
certified.
Have you annexed the copy of the application for certified copy?
Yes, my lord, yes.
Have you annexed?
Yes, my lord, I have annexed.
Yes. Give.
Lordship, may
Developers.
Lordship, may I be allowed to mention one section 37 appeal? Lordship, you have made this matter returnable on 25th of April. Mr. Bagh is appearing for this matter due to some
So
personal.
27th of April, it will appear.
Sorry, Lordship, this will appear on 25th of April, Lordship.
So 25th, it will appear.
Lordship, one indulgence, Mr. Bagh is appearing for this matter and due to some personal difficulty, he won't be able to.
Please circulate a letter and then on that day when it will be listed, just tell us. Yes. Call.
Original side matter. We mentioned item number 1.
My lord, this is appearing at my instance, my lord. Only one correction in the first line of the order. Instead of appellant, it should be, my lord, respondent.
Yes, come. This matter is mentioned for correction of a typographical error crept up in the order dated 23rd March 2023. It has been indicated that in the first line of the order, the word within quotes appellant has been wrongly inserted instead of within quotes respondent. Such mistake is apparent. Let the word appellant be substituted by the word respondent in the order dated 23rd March 2023. This order shall be read conjointly with the order dated 23rd of April 2020.
Grateful, my lord.
Item number 2. New application.
My lord, in this matter, my appeal, my lord, only problem is, my lord, this client is outstation. My lord, we have been not, there's a question of payment of money, my lord. That's really the, my lord, challenge to the, my lord, order. Lord, kindly, my lord, takes it up on Tuesday, my lord, we were unable to, my lord.
In first 5 matters, we have
No, no,
already indicated.
I'm
Why
ready to-
why you did not circulate a letter
My lord, and
that you are in some difficulty today?
my lord, we wanted to mention, but since the matter
No,
is
sir.
there in the list,
No,
my
so
lord,
you could have circulated the letter. Then what is the necessity of giving a special note in
my
the
lord,
cause list?
my lord, we have just filed the, I understand.
Whatever,
I've
you
read the
knew
note.
it that you are unable to contact with your client.
I
You could have
till
circulated the
yesterday
letter.
evening, my lord, we tried, my lord.
Sorry,
It's a
sorry, this
question of
can't be done.
payment of money, my lord, how
Sorry,
much
it's
money
a-
we
it's
can
a-
deposit, my lord.
Sorry, it's a judicial order which is to be passed. It does not depend upon what the client thinks.
No, it's not about client things, my lord.
Straight
Kindly
away.
see, the crux of the matter is, my lord, we are defaulters in a loan agreement. My lord, we surrendered the vehicle, only vehicle concerned, we have surrendered the vehicle. My lord, now the receiver has put it up for auction. The highest auction purchase price that has been fetched is 20,50,000.
No doubt.
Now, my lord, we wanted to, my lord, say, Lord, as a mercy, my lord, plea before the learned trial judge that we want to put in 20,50,000, my lord, in 2 installments. Kindly allow us, because that's really
Why
my
two
bread and butter.
installments? You pay it at one go. Pay it.
My lord, the learned judges.
Because it was your vehicle. because
Yes, my
you
lord,
were-
that's the
you
only,
were
my lord,
doing it.
means of, my lord, livelihood for my family. But
So
I said
we
I am
can-
going to.
We can definitely on a humanitarian
Two
ground, we can
installments,
permit
my lord.
because that's the highest offer.
Yes.
If you can match the
I
highest
want to
offer,
match that, my lord.
we will.
But if
there's
if
no
your lordship
difficulty.
gives 2 installments, my lord.
No, sir. No, why installments? There is a past incident that you have failed. And can the court rely you that you will
But
not
I can make some immediate upfront payment.
immediate
within-
full
that's why
payment?
I
You
said-
come with the full amount of money, no problem. 20 lakhs, 50,000.
My lord, in fact,
And
they
then
had-
if there is a surplus,
Very nice.
you will get back.
But
But if your
can that
lordship
be
kindly
Thursday then?
takes-
That's what I'm saying.
if your lordship kindly takes up page number 16, that is the impugned order. So if your
No,
lordship
I'm
kindly
looking
takes-
at
Yes,
the impugned order from the memorandum of appeal.
So my lord, they themselves offered initially 21 lakh. That is their offer.
Now you got the highest offer at 20 lakh 50,000.
Yes.
If they can pay 20 lakh 50,000, at least some kind of an equity should
Equity,
play in their play, in their
My lord,
favor.
21 lakh they have stated. themselves.
Whatever is, sir, you could not, they get the offer of 21 lakhs,
Yes.
50,000 less. If they can match, what is the difficulty?
Very well.
Equity
Because
plays in their favor.
my lord, I completely bow down to that, my lord.
So-
My lord, in this particular matter, we are already holding a demand draft. So if my learned friend comes up with a demand draft, and if the court considers.
Don't worry, we will concern with the cash. Don't worry. Way of demand draft,
22 lakh.
no check, or by way of pay order, whatever, or a banker's check, whatever. So that there is no question of any dishonor.
Dishonor.
No question. We'll ensure.
Very well. Well, let them
But-
take instructions, come back.
Yes, kindly, my lord.
It is submitted on behalf of the appellant that they could not contact with their clients to apprise the court as to whether they are ready and willing to deposit the amount indicated in the impugned order dated 23rd March 2023. However, the counsel for the appellant submits that they are ready and willing to deposit the sum of rupees 20 lakh 50,000, being the highest offer received by the receiver. And in order to arrange the same, some time is required. In view of the categorical stand taken by the appellant, let this matter be listed on Thursday under the same hearing.
But just one small thing, my lord, they themselves offered 21 before the court below.
Sir, I heard
Oh.
you told me thrice.
Lordship's memory, my lord.
Grateful, my lord.
Item number 3.
I'm appearing on behalf of the defendant bank manager. Then I am for the appellant.
You are for SDFC Bank.
Then may I, my lord, give a short background of the present situation.
Where is the supplementary affidavit? Have you filed?
No, my lord, my learned friend was to file.
Oh, applicant. This is an application for addition.
Not my lord. Yes, his application for addition.
Yes. Affidavits are complete.
Yes, my lord.
Which application is this?
GA2, my lord.
GA2.
Yes, my lord. Lord, my learned friend had
Give us
completed.
the
I will
opposition.
just take, my lord,
And the reply. As well as a supplementary affidavit. Yes. You বলবেন? No, no. There are two oppositions, one by affirmed by Devojit Mukherjee and one affirmed by Ajay Kumar Singh.
Devojit Mukherjee is the bank's.
Is a bank. And then what about Ajay?
Is that? Ajay ki? Kumare? Ajay.
He's a director and constitutional attorney of the appellant. So is the appellant who has filed. Say so.
I'm sorry, my lord.
I was asking that
Oh, I
whose
did- I
affidavit
didn't
opposition is this?
I didn't hear that, my lord. I'm sorry, my lord. My lord, I'll just take, I'll agree to whatever your lordship feels, my lord. I'll just take, my lord, 2 minutes of your lordship's time. You know, this is an appeal, my lord, from an order allowing, my lord, Order 7, Rule 11. In that appeal, my lord, if your lordships feel, my lord, that it is proper that somebody be brought in, Lord, we, my lord, will not stand in the way.
Section 34 of
Section.
which act?
Sir, I'm sorry,
It
sir.
says barred under section 34 of
So that's
surfacing.
securitization, surfacing.
Surfacing. Now there is a recent judgment of the Supreme Court 3 days before. Yes, you were supposed to give a supplementary
My lord,
affidavit.
I have given lordship.
Where is the supplementary affidavit?
Last occasion, my lord was pleased to observe that where to put the
Where
contract
is the
note in.
supplementary affidavit?
I made it in 2 volumes, my lordship.
Yes. Show us that money belongs to you
Lordship. Lordship first,
or the shares belongs to you.
my lord. From the first annexure in the supplementary affidavit, lordship, at page 7,
Yes.
lordship, one of the applicants' share was transferred to the applicant's account, lordship, which I put into record, lordship. It was stock holding.
This was in the name of,
It was in name of Pushpa Devi Mahota, lordship.
and who is this Madhav Prakash Mohta?
Madhav Prakash Mahota is one of the applicant, lordship.
Yes, which property?
Lordship, the stocks, lordship.
Which property?
Property, lordship, the BA from Stock Holding Corporation Limited to lordship, it was transferred.
Which one is the property? Where it is situated?
Lordship, the stock,
I'm asking you, you have given your address.
my lord,
Where is
29,
property?
20,
Where it is situated?
29, lordship.
Where it
Strand
is
Road,
situated?
lordship. 29 Strand Road, lordship.
Where it is situated? Your client is here?
Yes, lordship, he's outside, just outside.
Ask him. Where it is situated?
Lordship, within the Bara Bazar jurisdiction of this honorable.
I'm asking you where it is situated, which place?
Strand Road, 29 Strand Road, lordship.
Stand road means what? No, then, sorry,
No, Lord,
I was a receiver at one point of time of this.
29
Lord, kindly, my lord, Lord, we have no objection, my
Lordship,
lord.
this is not concerned with the building.
I have an objection. You may not
Lord,
have
I
an
will lose
objection.
the chance,
It
my
is
lord.
my conscience. Sorry. I had an interaction with all the clients, your clients, their
Lord,
clients.
Please record, my lord,
No.
we will never have any objection.
No, sir. I have an objection.
No, no, no.
You may not have an
Please
objection.
don't have an objection, my lord.
Since one of I was dealing with those properties at one point of time. Yes. And I was interacting with all the owners of the property.
My lord, your lordship doesn't know his
Sorry,
client.
sorry, sorry. I
But
didn't notice that earlier.
Kindly, my
The
lord.
moment he referred me, the first annexure, I find the name.
My lord, at least I'll get a
Sorry, they
hearing
used to
of
come
my,
to my house
my lord, many years
frequently.
ago.
No.
My lord,
No.
please, my lord.
Since one of us, give my name, is not inclined to take up this matter on his personal ground, let this matter be released from this bench and be placed before the Honorable Chief Justice for passing an appropriate order for assignment.
My lord, I'm ready to file an affidavit also, my lord.
I have an objection, sir.
My lord, we don't have an objection
You may
coming
not
to.
have, but I have an objection. I have an objection. You can't do it. It's my conscience which is paramount. I really respect and appreciate your stand or the gestures which you have shown, but still my conscience is paramount. If I feel that I have interacted with some of them, why should I take up the matter? No, sorry, I can't.
My lord, he can say, my lord, whether there's any interaction in the past, my lord.
I am saying, who
Maybe
is
not
the-
with his client.
with
And
his,
I'll take his
with
word
his
for it.
client, with his client. The gentleman is standing behind.
I still have no
Oh,
objection.
sorry, I can't. I have an objection.
Maybe a new tenant of 29 standard.
What?
He could have been a new tenant.
Tenant is the owner. If you want the history, I can tell you the history of the entire property.
Don't have any objection. my lord.
So, sorry.
This is about history of shares, my lord.
No, whatever. Sorry, my conscience is, sorry, it does not permit me. Yes. Call the next.
Item number 4, 5 and 6.
Item numbers 4, 5 and 6, my lord, are for the appellant led by Mr. Jishu Shah. He's on the online platform, my lord. My lord, I am led by Mr. Shah. He's on the online platform.
Well, with your lordship's leave, my lord. Sorry, my lord, this is a matter which your lordships have considered earlier. It's a section 5 application. My lord, there is, my lord, a delay, my lord, and we are conscious. And my lord, your lordship is also, my lord, not in the same matter.
Mr. Shah starts. I am for the respondent, my lord. I was told, my lord, they would be seeking an adjournment. A letter was circulated. The matter was mentioned yesterday.
No, my lord, that is, I am now not in station, my lord, it is absolutely correct. But my lord, I also know your lordship's, my lord, indication in the list with regard to the first 10 matters. But I would be, my lord, very grateful if your lordship, my lord, accommodates me on Tuesday. But I also know, my lord, your lordship's, my lord, direction in the list.
Now, once the letter is circulated, an impression is given that you will be seeking an adjournment, Mr. Saha.
That's right, but my lord, I'm online because I know your lordship's practice direction.
No, online I always permit whether there is any direction or not direction, because I also encourage this online hearing. I always, all throughout. So there is
And
no.
my lord, I am very
Yeah.
pleasantly surprised to find, my lord, that now your lordships are live streaming. The quality of the video and the quality of the audio is so much better. And it's so easy to, my lord, address your lordships. if
No,
you
there's
are
no
doing-
difficulty. That's why we have taken a decision in this regard, and I particularly this bench, at least I can share with my brother as well. We always permit whether there is a resolution or there is no resolution. We always permit online. Anybody who is interested. So what to do now, Mr. Chaudhary?
My lord, kindly keep it on
Down with the
Tuesday.
fever.
Your lordship will come.
Down with the
Next
fever.
Tuesday.
Here's him, my lord. I can, my lord, come back on another day, or my lord, I can start.
My lord, if your lordship will give us, my lord, next
Not my lord.
Tuesday or Thursday, whenever it's coming.
Would you like to come on Thursday?
My lord, we come back next Thursday.
This
In that-
Thursday? Sorry, Tuesday.
Yes, Tuesday, lordship keeps it
Tuesday, then you come.
Yes, my lord. Yes, my lord. I'm very grateful.
It is. The letter seeking adjournment was circulated. to the advocate and record of the respondent that the counsel for the appellant is indisposed. However, in course of hearing, the respondent submits that the senior counsel is suffering from fever and unable to attend the court today. In view of the above, let this matter be listed on Tuesday
Grateful.
under the same head.
Great, very great.
All these three matters?
All these three matters.
Yes, my lord, they're connected.
So where are you now?
Well, I'm in Delhi, my lord.
That's the unique feature of the online facilities.
But I would, my lord, prefer to be in Kolkata and, my lord, then be in Delhi. instead of
That's
being in
true, but
Delhi and then
at least the matters are being touched, the matters are being taken up.
Yes, my lord.
Adjournments are not sought on that ground that the council is out of station.
Yes, my lord. That's correct. That's absolutely correct.
Yes, thank you.
Grateful, my lord.
Appellate side matter, extension of interim order, item number 1.
I am for the appellant. But in this matter, my lord, this is an infringement come passing of action. The learned
Creams,
court below,
confectionery and creams cakes.
yes, my lord, the learned court below, my lord, held prima facie case, balance of convenience, irretrievable prejudice, all are in the plaintiff's favor. However, invoking inherent jurisdiction of the court, my lord, the court, extraordinary jurisdiction of the court, my lord, directed issuance of notice at the ad interim stage. We, my lord, filed an appeal. The Honorable Division Bench, my lord, was pleased to pass an order of ad interim injunction on 5th of April 2023. And, my lord, the matter, my lord, was thereafter, my lord, directed to appear. My lord, we have served, my lord. I believe my learned friend is appearing. Now, my lord, there is an inadvertent error in the cause title. Only the word limited is, my lord, missing. My lord, if your lordship.
Creams, cakes and bakes limited.
Yes,
Private
they defended.
Private limited.
Private limited. If your lordship gives me, my lord, leave to correct, I'll immediately correct that. And my lord, may I file the affidavit of service? I believe my learned friend had mentioned the matter in the morning, saying that vacating application, they were having difficulty. My lord, we apologize for this.
But I was told by your immediate junior that you have already approached the single bench and the leave has been granted to incorporate.
Yes, but
So that has been done because
believe it's been
their
done.
contention was it has not been done.
my lord, I am instructed it's my lord done.
So
No,
then
it has not been done because we can't file it in the department. That is
the-
why we wanted
if
the
the department is not aware of that fact, then you can't blame them. Once they have come up at that, they have already corrected it so far as the plaint and injunction application is concerned. Now memorandum has to be corrected in the light of that.
But
Yes.
my lord, only one other thing, my lord, I am opposing the
You
extension.
oppose. You oppose.
The only ground
Let
is-
let us first correct the record.
I'm sorry.
The respondent appears and submits that they intend to file an application seeking variation, vacation, and or the setting aside of the interim order. But because of the description of the respondent, the department has refused to accept the same. It is indicated that the respondents have been shown as within quotes, creams, cakes, and bakes. Which is in fact a private limited company. Stop. To which the semicolon, to which the learned advocate for the appellant responded that a leave was sought from the it's a trial court or a
Then commercial court, my lord.
it was sought from the commercial court to correct the description of the respondent in the plaint as well as the injunction application, which in fact had been which was granted, and the correction have been made. The respondent has now been categorized as within court Creams, Cakes and Bakes Private Limited. Stop. However, we find that the respondents are described in an unamended manner, as the private limited has been omitted. Full stop. Since the leave had already been granted by the commercial court and the corrections have been made, further leave is granted to the appellant to correct the description of the respondent. The date of upload of the order. Shown in the cost title of the memorandum of appeal, as well as an application being CN 1 of 2023. Your advocate and record is here and now. Correct it. The other. Hey, give it to them to make a corrections. It all copy to the way.
কেন দিচ্ছি আমি বার করে নিচ্ছি আমি এত সিনিয়র হইনি
Let it be done first.
Yes, yes.
দিয়েছে তো আপনার
May I, my lord, use this time to make a suggestion to my learned friend. Lord, we are, and since he is here, I'm sure he has far more experience in this. We have, my lord, 50-50 shareholding in this company,
Which company?
in the plaintiff company.
Okay.
Now, my lord, 50% shareholder moving out and using, my lord, the same mark. Now, that's what my contention is. I don't, my lord, expect my learned friend to agree, but we can agree to this, my lord. He can, my lord, move out of the company. I'll buy out his shareholding. We can agree to a different set of marks for each of us and we can continue. That will, my lord, provide a solution for this suit. There's another suit which is pending. So, my lord, it will be a clean solution. He's a 50% shareholder of the plaintiff. My lord, if he wants, I can buy him out at a valuation which can be done. And, my lord, even after that, my lord, it will be the plaintiff who has this mark. So, my lord, we can agree, my lord, and my learned friend's experience will come into operation there, my lord, that we can segregate and sever the two marks so that it is not distinctively similar. But this is, my lord, a suggestion I have. If my learned friend agrees.
fair suggestion, but this is not how the plain proceeds that I am a 50% shareholder.
It doesn't.
It doesn't. Plain
That's
doesn't
another
proceeds. I am a 50% shareholder on the basis of which the injunction is sought from the division bench.
Correct.
It doesn't recognize me as if I'm a third party outsider. Now, my lord, it's well settled.
Now he says that you are holding a 50% share.
Yes,
Yes.
so my lord, what
Well,
is the
that's-
effect of the mark?
That's, my lord, another
Now-
suit I have filed where, my lord, my cause of action is that my shareholder cannot run a competing business in view of the provisions of the
So
Companies Act.
I think you should just make a
have
thought
Explore
of,
this and proceed with
make
this.
a
I have
thought
no
on that.
objection.
Fair suggestion. Now, my lord, two things I say, and I, my lord, matter will be posted. I have a vacating on the board, lordship will, I will ask leave for filing it. My lord, the order which my learned friend has got, my lord, there was the express direction, service has to be made within 48 hours. That has not been done.
Oh, you are arguing on merit. That is the one issue.
Kindly-
Now, please,
My lord, on extension, I'm
please, when
speaking.
a suggestion has come,
My lord, suggestion, my lord,
and an amicable solution is sought to be achieved, then you'll have to really forget the past and just think in present and for future. So if your client is agreeable to sit across the table and think over it, that's the
I'll
one
take
thing. If you say no, under no
I cannot
circumstances,
take the decision now.
yes,
Since
under no circumstances we can go for that kind of a solution, then we'll have to proceed and hear out the matter.
Sir, I don't have the instruction today.
So
this is
would
just
you
the-
like to take an instruction and
Yes,
then come back?
on Tuesday. Come back on Tuesday.
Come on Tuesday.
Did you call him? That Millard, kindly Millard, as it is, keeps it on Tuesday, Millard, he will be entitled to apply, Millard. I will not stand in the way.
I think the interim order is up to Tuesday.
Tuesday.
Tuesday, we can come back on Tuesday and argue.
No, 20. Okay. No, it's-
Still yesterday,
Till yesterday. So
There's a
kindly will not
non-compliance.
extend it till Tuesday. We'll
there is
come
a
back.
non-compliance. Kindly don't.
No,
do
no,
that.
there's no non.
There's a non-compliance. Kindly take it.
We will keep it that. Don't worry, when a solution has come, we will definitely keep all the points open.
We posted it within time.
You-
ওখানে ভুল দিয়েছে আমার এখানে দেখো 6th April. There's no non-compliance.
Millard, status say, Millard, it's on 8th.
Yes, but I have posted it on the 6th and it's there.
Is there.
Millard,
So that
kindly
is
take
postal receipt will show if there is a,
Track report.
that is what, if there is a wrong inputs given in the server, wrong inputs, you
No,
can't
no,
take
I
advantage.
I have the envelope.
They have the postal receipts if they have with them
এখানে কোথায় আছে?
on 6.
এই দেখো 6 তারিখে করেছি।
Millard,
So that itself is a, so please think over it.
Also,
If you
there's
can,
one-
if
one more
both of you
problem.
can come to an amicable solution. I do not know. I think both of you are related, family,
No, my lord, friends.
friends.
But this is something which should be settled.
ক্রিমস এর উপর কারোর রাইট থাকবে না সেপারেট লেভেলে ইউজ করবে
Should come.
বলে নাও দ্যাট ইজ দি থিং ইউ ক্যান গেট লেভেল মার্ক
The matter has come up for extension of interim order passed by the coordinate bench. First of, Mr. Chaudhary, the learned advocate appearing for the appellant at the very outset submits that there is a possibility of an amicable solution to the disputes
মাত্র ক্রিম জমা তো সামনে আর দি আদার ডিস্টিংগুইশ
and have also indicated the
আই ইউজ দ্য
possible solutions. The terms of the possible solution to Mr. Ghosh, the learned advocate appearing for the response.
দেখি নাও।
Mr. Ghosh in his fairness submits that without any instruction
আমি এই স্টাইলটা আমি ইউজ করবো না
and or concurrence from his client, he is not in a position to respond
solution otherwise এটা হবে
to the aforesaid terms of possible solutions. In view of the above, let this matter be listed on Tuesday.
some other
Under the same heading.
তুমি
When both the councils have
I go out on a
disclosed
and I
the,
res-
the stand of the respective parties. Since the interim order was operative for a considerable period of time, the same is extended till Tuesday.
the addition of
That is the date be allowed or until further order, whichever is allowed. You just think over it. You just think over it and
I have
then.
given him a
if it-
solution also, Vinod.
Yes,
He's also provided, Miller, I'll also take instructions.
come on Tuesday,
Before that,
at
we'll
least
do-
show if there is any ray of hope, then we can. If you say parties are stubborn on
Then
those.
Then
no
being
problem.
stubborn, Millard will not help.
Yes.
Millard 50-50 shareholder, neither I can restrain him nor can he restrain me. This is Millard, the subject on the subject.
That's true.
That is
That's
I've got it.
that's the legal point.
He has given a suggestion, I have given a counter.
That's why I say it's a legal point. And the moment these are projected a front problem of amicable solutions. Yes, come on the next. Item number 2.
Mr. Anirudh, I have been asked Lordship by his clerk, Anirudh Bhattacharya is appearing a Lordship in court number 23. He's on legs. He's doing a Passover only. He has asked me to ask for a Passover. Lordship.
I cannot stand in the way. There's a section.
Passover.
But
Deep level.
Passover.
Item number 3.
This is my appeal, my lord. Your lordship will recollect, my lord, on the last day.
Appeal or application? It's an application.
It's an application. On the last day, Miss Bhutoria was leading me. This is that matter where my transfer application before the trial court was dismissed, and I came up in appeal. My lord,
How appeal lies?
My lord, what was the view? How appeal lies, and my lord, we placed section 15, which according to my lord, it contemplates an application. My lord, then, my lord, we also beseeched your lordship on the issue that perhaps the rules as a stand down the appellate side, they do not contemplate filing an application.
But if the law says an application, then you can't term it as an appeal.
That is there. When I join
What
issue
can
there,
be
my lord,
done?
that
What can be done?
the application has to be filed.
Yes.
But my lord, as
So
per
this
my lord,
is
I am
either
a-
you withdraw or we have to lay down the law and dismiss it.
difficulty is,
Holding
my
that
lord, I am-
appeal is not maintainable.
my lord, 227 in that case, my lord, I cannot approach the 227 court either. When in view of section 15 of the Commercial Courts Act, because the power is only vested with my lord. On my limited understanding, my lord, I perhaps cannot file a original application in the Commercial Appellate Division seeking
I do not
transfer.
know. Then go and
we
let
looked
the
up,
law
but
and
like-
get the law amended. If the law stands as
cannot-
on day,
but with the
talks about the
greatest
application, then
respect,
one
my
has
lord,
to
I cannot
understand.
be without a remedy. My lord, my
No,
application now
it's not
stands
it's not
dismissed.
that particular the legal maxim.
May I just indicate something? Well, the Delhi High Court, my lord, has a provision for transfer. The transfer petition is filed.
I do not know what is there. I do not know. We are concerned with our rules. Tell us. It is not that those applications cannot be registered. If the law permits an application to be registered, it has to be registered.
If I can persuade my lords, my lord, this is on a transfer petition, and my lord, there have been instances before in this honorable court, my lord, when similar orders have been passed in appeals. And I will be
But
candid, my lord,
suppose
that
if there is a
this point was
wrong
not
order,
raised. My
there's a
lord,
wrong order,
I bow down, my lord.
does it mean that the
It does
coordinate
not, it
bench
does
is
not.
bound by it?
It does not, my lord.
So the law has to be understood in this perspective. This is what the very first sentence talks about this.
Yes,
So you go and file an application.
my lord, difficulty is, my lord, my learned advocate on record is also saying that the difficulty will be in filing the application because the rules do not contemplate filing an application.
Then I
in the
say in an administrative capacity, there is no difficulty.
Then my lord kindly gives me that liberty, my lord.
There is
Lord
no
41
difficulty.
Rule 33,
There is
my
no
lord, my lord
difficulty.
is vested with the power.
An application. Yes. It is really a transfer petition. We will make it civil number. This is how they categorize it.
SCC online SC. अरे काल के मैं विमल का बोल रहा था
Or Peter, C stands for commercial division. We can suggest CO and quantity. Civil he stands for transfer percent 24 transfer petition. Correct. C stands আমাদের এখানে civil বলা হয় আমরা যদি এটাকে COM করে দিই and it will come out the commercial.
Indirectly, also. Indirectly, also. No, not yet. That place section 15 subsection 5 on the last.
I'm looking at it, sir. It talks about an application in the judgment which you are refer of the Delhi High Court. Very first line,
Yes,
it
sir.
shows that it is a transfer petition which was filed.
One of this
It
petition
was never
can
an
only be done
appeal
under
which was filed.
Section 24, but one of the section 24 court is not the commercial appellate division. But I will face a difficulty there.
No,
also.
this was filed under section 15(5) before the
15(5).
Delhi High Court. So they have given a nomenclature of a particular applications that they would be registered as TRPC.
TRPC, yes, your lord.
So the TR stands for transfer, P stands for petition. Now what we are suggesting, the C sometimes we connotes as civil. Yeah. So we can direct COMM to be used so that it will denote a commercial.
Grateful, my lord.
And then the registration has to be done.
My lord, gives me a liberty, my lord, I will, my lord. file an
What liberty? There is no limitation provided therefore.
The liberty, my lord,
Sections 15(5) does not.
It may not be filed, could not have been, may not be filed, accepted by the department rather.
It will be.
Well, kindly
They
protect me,
can't
to
do it.
that extent. Well, I mean, led by Mrs. Botoria. madam.
So now some of the lawyers have dispensed with wearing the gown because of the mandate of the acting Chief Justice. Yes, yesterday it has been. So no difficulty. Dispensation of gown. The instant appeal has been preferred against an order dated 3rd February 2023 passed by this it's a commercial court. He talks about the civil just senior division.
This application was filed before the civil justice. The suit was pending before him.
So how an appeal lies before the commercial court? I am just asking.
15 subsection 5.
How?
We were saying that it is a commercial dispute.
You may think many things unless the court has decided, unless the court has said whether it comes within the dispute of the within the commercial dispute. It has to be first transferred to a commercial court, then you can come out. How can you come out of your own? Because you think it is a commercial dispute of a specified value. Sorry, we can't. No, I stand. If till date it has not been transferred, it has to be first transferred in a commercial division.
Sorry.
In a commercial court. No, tell me, let me understand the law.
Application which we had filed for
Yes.
transfer, that has been rejected.
True. That means the court is of the view that it is not a commercial dispute. Now, suppose if it is there, then what? Then if there is a remedy which is available,
Lordship 15(5), if your lordship can.
it's an application. It is an application when
In the
an
event,
what can be done?
in the event that such suit or application is not transferred.
Correct.
In the manner specified.
I'm on, please consider. Section 15(1)(2)(3) provides that how the transfer is to be made in respect of a suit pending in the regular civil court to a commercial court. Section 15(5) says that in the event the suit is not transferred to the commercial court, then you can take out an application. Suppose a application is dismissed by the regular civil court holding that no, it is not a commercial dispute, and therefore there is no necessity of transferring to the commercial court. Then it remained before the regular civil court. And whatever the remedy is available against such an order, means the order passed by the regular civil court, then that remedy has to be resorted to. I am giving you a very simple example. Suppose a suit is before the civil court. An objection is taken about its maintainability before the court, that this particular act debars the civil court from entertaining it. That act is contained in exhaustive provisions relating to any orders passed under that act to be susceptible to be challenged before the, say, higher forum by way of a appeal. The civil court rejected the application.
Yes.
Will you resort to a remedy under the special act? I am asking you a very simple question. Will you resort to a remedy under the special act? Or you have to challenge that order before a forum under the normal, which is applicable to a civil court?
If your lordship sees 15(5), it says that
I am again saying, sir, it talks about an application.
Yes, I
It is
agree.
why it is said that if you are aggrieved by any kind of an order passed by the regular civil court, refusing to act in terms of section 15(1), subsection 1, 2, or 3. Let us go. Then what is the remedy against that?
File an application.
Only 5 is an application, not an appeal. Or in other way, if those are passed by virtue of an inherent pass, if it can go to a higher forum, the higher forum may say that you are wrong, you could have.
But if your lordship sees, if it says, if the such suit or application is not transferred in the manner specified in subsection 1, subsection 2, or subsection 3, the commercial appellate division of the High Court may on the application.
Correct.
Now, the difficulty is, your lordship, that there is no.
There is a categorization. I had a talk with the respective registrar. There is no difficulty.
My instructions were that.
Wrong instructions.
Then, your lordship, may I pray this, your lordship? We'll just go and talk to the department again.
It's not there. It can't be when the statute provides particular application to be filed before the commercial appellate division, then they can't defy that they will not accept that application. It's a mandate, statutory mandate. And therefore the appeal does not lie.
No, that because we have also seen your lordship's judgment in Orissa, Surrey matter also, where your lordships have observed that it cannot be an appeal. In that case, if your lordship, we can press for withdrawal of this appeal with liberty to file the appropriate application. Your lordship.
That is already a statutory right.
Yes, but
Why
because we
liberty
have
is required? Why liberty is required?
Because, your lordship, once we withdraw the appeal, your lordship, it might.
No, if the appeal is incompetent, then
That's why, lordship, I was saying that.
leave is always required when the proceeding is competent. For some fatal defects, you want to withdraw and file it again, then a liberty can be granted or leave can be granted.
Your lordship, we have filed the appeal for that purpose only, your lordship. If your lordship gives us that leave, then we can.
The
go and
instant
file
appeal
application.
arises from an order dated such and such, passed by the civil judge, senior division, Shalda, in title suit number 166 of 2010, by which an application seeking transfer of the said suit to the commercial court is rejected. The aforesaid suit was instituted prior to the promulgation of the Commercial Courts Act 2015. Full stop. The said suit is primarily for passing a decree for specific performance of an agreement for sale of the emerald property, which according to the appellant herein is exclusively used for trade and commerce, and therefore satisfies the definition of a commercial dispute defined under section 2 within bracket 1 within bracket C within bracket 7 of the Commercial Courts Act. The court below refused to accept the aforesaid contention and declined to transfer the suit to the commercial court. We must remember that the right of appeal emanates from a statutory provisions, from the statute. The party cannot assume the remedy by way of an appeal if the statute does not provide so. Section 13 of the Commercial Courts Act 2015 contain an exhaustive provision relating to a remedy by way of an appeal in favor of a person aggrieved by a judgment and order of the commercial court. By Act of 28 of 2018, the original subsection 1 have been reintroduced with certain amendments, more particularly incorporating subsection 1 capital A with the proviso added thereto. It is beyond cavil of doubt that any person aggrieved by a judgment and order of the commercial court may appeal to a commercial appellate court within the period of limitation provided therein. But if the appeal is filed against any order passed by the commercial division or the commercial court, it must satisfy that such order is amenable to be challenged by way of an appeal under Order 43 of the Code of Civil Procedure and Section 37 of the Arbitration and Conciliation Act 1996. The order passed by the court below the nature of the order passed by the court below has not been included in in order 43 of the Code of Procedure so as to make it appellable at the behest of the party aggrieved, and therefore the instant appeal, in our opinion, is not maintainable. However, we notice the provisions contained in section 15 within bracket 5 of the said act, providing a remedy to a person aggrieved by an order of the court refusing to transfer the pending cases to the commercial court. The aforesaid provision is quoted as under. Please quote 15(5). The bare reading, next paragraph, the bare reading of the aforementioned provisions leaves no ambiguity in our mind that in the event the suit pending before the civil court or an application is not transferred under subsection 1, 2 and 3 of section 15, the commercial appellate division of the High Court may, on an application taken out by any of the parties to the suit, withdraw such suit or an application from the court where the aforesaid proceeding is pending and transfer the same for trial or disposal to the commercial division or the commercial court as the case may be, having a territorial jurisdiction over such suit. The logical inference which can be drawn from the aforesaid provision that the remedy by way of an appeal has not been provided, but an application before the commercial appellate division of the High Court may be filed seeking to achieve the same goal as intended to achieve by way of an appeal, which is admittedly not permissible. We have been informed by the appearing counsel that the department may not receive the application to be filed directly before the commercial appellate division of this court. But
I'm not disturbing anybody.
But we do not find such apprehension to be correct. The moment the statute has provided an application to be filed before the commercial appellate division of the High Court, the department cannot deny such a statutory right to be defeated or denied, nor we expect such course to be adopted. We notice from the judgment of the Delhi High Court rendered in Satyanarayana Khandelwal versus Prem Arora, reported in 2022 SCC Online Delhi 2142, that the aforesaid transfer applications filed under section 15 within bracket 5 of the said act are registered as capital T, capital R, full stop P, full stop within bracket capital C. so as to distinguish it from the other transfer applications filed under the different provisions. So far as this High Court is concerned, the alphabetical letter C within the bracket may connote different category of the petition, and therefore we suggest that the application under section 15 within bracket 5 of the SID Act should be registered as TR full stop P within bracket COMM bracket close, so as to distinguish it from the other category of the petition seeking transfer. Next one. Since the appeal is not maintainable under section 13 of the SID Act, the same is hereby dismissed. However, it is open to the appellant to take an appropriate steps as permitted under the law, if so advised. So let the certified copy of the impugned order be returned to the advocate and record of the appellant upon replacement with certified copy thereof, so that at least you can annex it.
Yeah, and I apologize because I submitted on the instructions of my advocate on record that application is not accepted. I didn't know about it.
We had inquired and there is no difficulty, and we have suggested, because we find it's a very unique way, is a good way of categorizing these kind of an applications. No difficulty. So let us come back.
Commercial কোর্টে পাঠিয়ে দেন, আমি তো commercial কোর্টেই গেছি। It has to be a commercial subject matter, has to be a commercial. এটা হয়ে গেল তো? হ্যাঁ? আমি বলছি বুঝতে পারছি, এই তো লাল বই আইতে বল। আধ ঘন্টা চালাতে পারলে ভালো।
Bank finance transaction.
Why I say so, my lord? 3 original title deed,
Just 1 minute.
something which is impossible. And
Just-
now it has been.
It's a money
possible.
suit. It's a money suit.
Money suit for in the nature of restitution. I have been compelled to pay 1 crore 50 lakhs for
You are
protect-
assailing which order?
the first order. Well, leave under section 12A granted, but no urgency found for an ad interim relief. But before your lordship looks at the order, may I give your lordship very briefly the unusual facts of this case, my lord. Why? But what is the suit about? Suit is in the nature of restitution. Why restitution? I have been compelled to pay 1 crore 50 lakhs to protect my property in terms of a securitization notice. Without prejudice, I paid this money to them, and now it has been found that all the deeds of guarantee that they have relied upon, this asset reconstruction company has relied upon, are forged and fabricated. Not even that, my lord. In the course of events, 3 title deeds claimed to be all originals have come produced by 2 different banks in respect of self-same property. Yes, my lord. That is why, my lord, I started start clean facts. And all has been established on the basis of police investigation. But if I now tell your lordship, my lord, I am the owner of my father was the owner of a property in New Alipur. There was an agreement for sale with one Lodhas. There were certain disputes between me and my purchaser. The agreement for sale did not materialize to a conveyance. I handed over original title deed to those Lodhas. Part possession also handed over to them. This was the situation. There was certain disputes between me and my prospective purchaser. Then, my lord, suddenly I receive a notice under 13(2) from United Bank of India. Sorry, UCO Bank. First notice is by UCO Bank, alleging that this property is secured by a mortgage. I am the guarantor in respect of a financial assistance given to one company. Then there was a proceeding before the DRT at the instance of this UCO Bank. I intervened in that proceeding. And my lord, there was a direction by UCO Bank, by the DRT for production of original title deed by my prospective purchaser. That title deed came to be deposited before the DRT by the prospective purchaser. So, my lord, first title deed came to be deposited.
That was the title deed which you handed over to your prospective
That is my
purchaser.
case was that I have handed over to them.
So they produced the original.
Yes, they produced the original. There was one original.
So that logical inference one can draw is that though that title deed was never put as a collateral security with the bank.
Yes. So, my lord, at that stage, this was not revealed. Bank produced one deed to DRT. Another second deed comes from the Lodhas to the DRT.
Second deed means
the original, which I say is the original.
Correct.
Which I say is the original.
Correct.
So, my lord, this was the situation. Then they wanted to take away that deed from the bank, from the DRT. I filed the Lodhas.
Okay.
So I filed a civil suit before this honorable court that the deed should be returned back to me. And there was an order of injunction by this honorable court that the deed should not be returned to the Lodhas. It should be kept with them, with the bank.
With the bank or with the DRT?
With the DRT. So this was the position in 2010, this interim order. This continued until 2016. And 2016, that suit was dismissed for default.
Your suit.
My suit.
Yes.
Now, thereafter, another 13(4) notice I received from an asset reconstruction company. This is very interesting. They are now assignee of another bank. First was UCO Bank. UBI. UBI. On the basis of a purported deed of assignment, again alleging that I am a guarantor and the property has been mortgaged to them. I have resisted by way of an letter that I am not a guarantor, everything, but dwelling house, I paid the money to Pegasus, which is the asset reconstruction company, to save my, it is a dwelling house, my lord. And at the same time, I filed a police complaint by way of, which was registered as an FIR in respect of this entire matter, that there has been interpolation, there has been fabrication, forgery of documents. Now that matter was, investigation was not proceeding. Then I approached this writ court before this honorable court, and an order was passed by the division bench, not directly protecting me, that but saying that the police has to proceed with a due expedition. Or may I just show you?
Whatever, then.
And then a right was given to me that in the event it is found that these are all forged documents and I have parted with money, I would have a right to recover the same. By way of filing of, naturally, my lord. Then, my lord, the final report comes from the police. Well, that your lordship will see. That resolves the entire controversy, but
It
surprise.
says that it is a forced deed.
Yes. And it says,
The final report, on
and
the
it
basis
says-
of the final report, was there any proceeding initiated against the persons?
that is the most surprising. Police says this is forged. This only deed which has been produced by the Lodhas, that is the original. But we cannot find out who are the persons involved in this forgery.
Then who has gone to the bank and submitted
That
that
the
forced
police did not
document?
say. But your lordship will just see the final report.
Interesting, interesting.
Very interesting, my lord. Kindly
Somebody
take
must have. And who is the beneficiary of that loan?
two companies, but they can't find out who the companies are, where the companies
It's
are.
a fictitious company.
Well, your lordship will just, may I just place that police report one?
Are they registered anywhere with the registrar of companies?
I do not know, my lord. Kindly come to page 295. But I am now concerned with my money has to come back. Kindly see, that is my suit. 295, your lordship will come.
And what happened to the DRT proceeding initiated by the UCO Bank? Where you intervened, where the direction was passed to produce the deed. There is an order not to give that
That
deed.
has been disposed of.
What, in what
Was that
manner?
ওখানে কি কোনো certificate হয়েছে? You know? Well, that I will find out, my lord, what has happened to that proceeding. But the second proceeding stood closed because I paid the money to Pegasus. Kindly come to 295, my lord.
And that original deed is still lying with the
Now-
Lodhas or with the-
Original deed, now I have settled with my prospective purchaser and he has handed over the deed to me.
So you have got the
Yes,
original deed. with
finally
you.
I've got, I had retained my possession by paying amount and the deed has also come back to me. He has given a no objection. He is not interested to proceed with that agreement for sale and he has given the deed to me. Kindly see, my lord, the brief facts of the case is that the FIR named accused persons and others entered into a criminal conspiracy to deprive. the
Now,
com-
who is the FIR named?
Yes,
accused
FIR, your
persons?
lordship will kindly see page 290, sorry, this is the chart sheet. No. I 236, kindly come to 236.
There is a photograph.
Then thereafter,
Is it 296? 296. These are the accused persons.
Oh, 236 I am looking.
296.
Sorry.
then it must be 237, my lord, your lord.
37 is the written.
আমার এখানে 236 FIR.
Formal.
FIR is 237.
Yes. Complainant is my client. Details of 7, serial number 7.
Is a very bad way of writing an annexure. What is this going on with your advocate and record? How would the annexures have been written? Overlapping certain, you know, the things which have been written. Look at it. This is a way.
I
Should have been somewhere so that it does not cover any writings there. You have indicated the Piyush Lodha and Animesh Mitro
Parmeshwari Devi Lodha
and Parmeshwari
number
Devi and
Animesh
Animesh Mitro and others.
and others. Of the borrower company, Tirupati Textiles.
Who Tirupati Textiles is
They were shown as borrowers.
so they are there. Who are the board of directors or who are the shareholders of that company? The Lodhas or somebody
No,
else?
Lodhas are the prospective purchasers.
I understand.
This
The
Animesh Mitro-
borrower who got the money from the bank is a Tirupati, you said, that
Yes.
company.
Kadambari and Tirupati.
Correct. Then who are the shareholders? Who are the directors of Tirupati and Kadambari? Is it Lodhas or somebody else?
But the Animesh Mitra, proprietor of Tirupati Textile, Animesh Mitra.
Proprietor.
Yes.
Yes. The money might have gone to their account.
Money, my concern with the greatest of
I
deed of
understand.
guarantee has been forged.
Sir, there's a big scam. This is a big fraud that has come. So one has to, being a rightful citizen, one must know what is happening.
And kindly see I am more the role of
Your
Pegasus.
case is very clear. I understood.
Yes.
But I am just thinking aloud.
How it has happened.
Something. Then
kindly.
Then what is a final report?
Yes, that is what I was showing. 295, your lordship will see.
The case is closed.
Strange.
Declaring.
Yes. Kindly come to my lord, just regarding the deeds, what they have said. Kindly read from the second paragraph. During investigation.
Then there are the offenders who have been made forgery could not be fixed up.
Yes.
Though there are a clear evidence of the offense of forgery on the deed.
And loan guarantee papers. And in respect of loan guarantee paper, loans from United Bank of India.
Several attempts were made to trace out these two companies. But those companies could not be traced out.
Yes.
When this loan was advanced?
My lord, if 2003.
I think at that point of time, the various other identity documents relating to identity are also required to be deposited. They must have deposited the PAN card. They must have deposited
Police
the
should have,
other.
seized all those documents.
Can't they find out the persons from that?
But I think, my lord, I should not say. They have just come to a conclusion regarding forgery. And having found that, your lordship knows what happens. Pressure. And then hush up.
What interim order you sought for?
My lord, I have sought for why? Because this asterisk, this Pegasus, which is a asset reconstruction, is a completely private entity.
True.
They don't have any funds or any reserves of their own. What they have done, my lord, I have found out, they have several fixed deposits. These are not their funds. Whatever funds of the bank have been assigned to them, those are those fixed deposits. And those fixed deposits, now they have charged it with another private bank, Karur Vysya Bank. So there is no reserve with them at all. And
Where your money went, which you deposited.
my money was paid to Pegasus. Your lordship will see that document. Kindly come to that document. I have paid to them. They've given me release. Page 233. Kindly come to, they have released all these documents after I paid to them. Page 233. Second paragraph. Pegasus on the basis of powers and rights vested upon them as.
No. 233 is to take over the position under section.
I'm
13,
sorry, my lord, one page.
Section
is-
14.
is One
Oh.
page. On the Pegasus on the basis of powers, rights vested upon them as per provisions of the above.
And this is the Kadambari is a limited company.
Yes.
Kadambari
Advanced
Steels
Kadambari
Limited.
Steels Limited. The address is also mentioned.
So
So this police has done nothing. And above personal guarantees are being released subject to payment of 1 crore 21 lakhs to Pegasus.
and when this final report was submitted before the judicial officer, they have not taken note of that.
2020.
Have they not taken any? Why they will accept it?
This has been accepted. Pegasus has accepted this.
No, not Pegasus. After the closure report has to be filed before the court, which is an FIR.
Complainant.
Complainant.
Complainant filed application against this report, final report. Report. And we filed the application.
Yes. Charge sheet submitted before the Court of Learned Chief Judicial Magistrate Alipur.
And did you file any applications challenging this particular
My
final
client?
report? Yes,
No.
because your FIR
Yes, I did
investigation,
not,
they
but
have
I did
closed
not
it.
because only of a specific reason. My lord, I have.
No, I
have
understand,
much.
but you should have.
I want to get
You
back
should
to-
have. You should have. Immediately, you should have taken a steps.
But against what, my lord? I have
No,
got back
against
my
what?
original. deed.
Whatever, sir. FIR is lost by you.
Yes, only to prove forgery.
This is not a question. Criminal, the act or the criminal
Absolutely.
provisions
Your
cannot
lordship
be
is correct,
activated
but
for a
kind-
limited
kindly-
purpose.
Kindly
It's a-
visualize what
After
the
all,
litigant
it's
has
the
undergone.
public money which the bank deals with. And
This is for.
there is a complete, the forgery which has been committed.
This is for the administration to find out.
No, sir, what are you saying under the criminal law? You have a
But
right.
see what I have gone
Right.
through.
Why you have a
After
right? No, I
fighting so
understand.
much.
We fully appreciate.
First is property.
No
a
problem.
shade above your
know.
head.
No, that's true.
And then the money.
But you should not, as a responsible citizen
I
of the
will, but
country.
once, my lord, 1 crore 21 is protected for me, I can.
Whatever is protection that will come. Where is the order of the writ court which
Yes.
says that you can?
Division bench order, my lord, lordship will kindly come to 281. It is only thereafter this final report came, otherwise the report was not coming. 281 is a division bench order. Writ petition was initially dismissed. I preferred an appeal. 282, it should be actually 282. A technical point was taken that a quashing petition is pending, therefore writ court in 226 should not interfere.
Where is your plaint?
Yes. Page 67, it starts, my lord. I've implemented Pegasus, Kadambari, then the one bank.
Why not the other bank?
The other bank, not because this forgery actually specifically found in respect of the UBI bank assignment. And I have paid only to the Pegasus, who was of the United
Or as
Bank.
a UCO bank?
UCO Bank, my lord, I did not have to part with the money. there. Deeds have also come to me. The original deed has come to me.
But it was not before the UCO Bank. The original deed was not there before the UCO Bank.
Yes, my lord.
The original deed was also not deposited
Yes,
with the UCO
yes,
Bank.
yes, original deed was not
Look
also.
at the order of the division bench. It says when you filed a suit for recovery, you will implead both the banks as a party.
My lord, actually, I have.
Why you will not? Whatever.
I
May
get the
not
logic,
have
because-
any claim against them. At least they should be arraigned as a party. The pro forma defendants.
That I will take steps.
You have not.
I will take steps.
And
there.
there is a specific mandate by the division bench that you'll have to make both the bank as a party in that suit.
No, but here, my lord, kindly see my
Please come to that portion of the order. Where is that order of the judge? You just showed me.
283.
Look at it, the last portion, penultimate paragraph of the order. At page 284.
It will be United Bank or represents such banks is
No, it's a 284. Come to this.
Yes.
So
But if your lordship sees my relief in the plain.
whatever, sir, you'll have to make them a
Well,
party.
I-
When
I-
there is a
I- that-
mandate,
Yes,
then how can you leave one party, one bank?
I
Because you have nothing to say about it. But their presence is very much necessary in view of the order of the division bench.
I will take steps, my lord. I will take steps there.
What interim order you asked for? Order 38 Rule 5?
In the nature of order 38 rule 5. my lord.
Why the trial court refused?
I'll kindly see there is absolutely, I greatest of respect, I do not find any reason. Lordship comes to the impugned order. Order number 2 dated 14th of March 2023. First IA 1 is taken up and the learned court grants leave under section 12 capital A. Then my lord, IA 2 is this application taken up. Paragraph 4, the entire fact is narrated.
Anyhow, at least before it proceeds to pass an order of attachment, at least the security has to be sought from the defendant number 1.
Yes, sir.
That's the first step under order 38.
Yes, that is.
Attachment will not come automatically.
No. And I have pleaded that, my lord, the fixed deposits which are there, they have already mortgaged it with Karur Vaisya Bank. That is my case in that application before the trial court. Your lordship can take paragraph 26 of the application.
Then what do you expect?
So
Now tell
therefore,
us.
my lord, I am saying, and they have made it, there is an overdraft account they are running. That overdraft account, there should be an injunction, my lord. That is the
Have you
minimum.
prayed for? Have you prayed for?
Yes, my lord, kindly see, my lord.
What
But
injunction?
some protection, your lordship will, on the facts of the case, your lordship will
Sir.
grant. I am not going to. Kindly come to page 150 to 53, prayer B, neither the prayer C. Yes, prayer C, my lord, page 154.
Alternatively,
Yes. And order, yes, my lord. Order of temporary injunction restraining from operating background mentioned in paragraph 35, creating third party interest in respect of any of its properties. So the properties, they have none.
why you wanted a security to the extent of 25 crores? Your recovery is only 1 crore and 40 lakhs which you paid.
Certain prayers, your lordship.
How can
I have made a claim for damages also, my lord.
it's a different, but
Yes,
actual
yes, well,
amount, principal amount is 1 crore 40 lakhs and
I will
25
prove
crores.
my damages, but 1 crore 25 is the admitted amount.
So
I am only to the extent of 1 crore 25, my lord.
21 or 25?
I am only asking for, my lord, that's 1 crore 21, which I am on the face of it paid on their document. And I have paid certain other amounts in cash, which I will have to prove.
the ex parte ad interim order for attachment before judgment under the provisions of Order 38 Rule 5 of the Codicil Procedure is refused by the Commercial Court, as the said provision invites a drastic remedy and therefore to be exercised with great caution and circumspection and not in a routine manner. The Commercial Court further highlighted that without giving an opportunity to disclose the defense by the contesting respondent, it would not be proper to pass an ex parte order in this regard. The facts, next paragraph, the facts emerged from the pleading is alarming and raises several issues which are of seminal importance in the trade and commerce and or the banking activities. In securing and or extending the loan facilities upon deposit of the security, upon deposit of the title deeds as security and is standing as a guarantor. The appellant is admittedly the owner of premises number 37B, Block B, New Alipo, Calcutta 53. And at one point of time intended to transfer, alienate, and sell the said property to the respondent number, the performer respondent number 5 and 6.
Only the ground floor. Transfer only the ground floor. But kindly. It's
Full.
perfect, perfect.
Yes, to the respondent number 5 and 6. An agreement was entered into, and in furtherance thereof, the original title deed of the said property was handed over to the aforesaid intending purchasers. Subsequently, a proceeding was initiated by UCO Bank before the Debt Recovery Tribunal, seeking to realize the amount advanced as a loan against a third party, and on the as the default has taken place, and an attempt was made to realize the amount as the title deed of the said property was put as a collateral security and or mortgage with the bank. Immediately upon coming to know of the aforesaid initiation of the proceeding, the appellant intervened, and an order was passed upon the said respondent number 5 and 6 to produce the original title deed, which was handed over by the appellant in pursuance of the agreement for sale. The said title deed was produced before the DRT. And was kept on record. To protect the said deed, a suit was instituted by the appellant, wherein an order of temporary injunction was granted not to give the said title deed to anybody. Stop. The said suit ultimately culminated into a decision for default. But it is a specific stand of the appellant that the said title deed was subsequently handed over to him, and he is in possession thereof. Interestingly, another proceeding was initiated by UBI against its borrowers. You were implicated as a party.
13-4 notice was given to me. Yes, by Pegasus as assignee of UBI.
UBI or not?
No.
Subsequently, interestingly, the appellant was served with a notice under section 13, within bracket 4 of the Sarfasi Act, alleging that being a guarantor and having deposited the title deed of the said property, he is jointly and severally liable for the loan amount advanced.
That's a relevant order documents, etc.
That led the appellant to take immediate steps by lodging an FIR, alleging that the original title deed, which is in their possession, was never handed over nor put as a collateral, security, or mortgage with the said bank for securing loans in favor of the third party. Stop. Since no progress could be seen in the scene on the basis of the said FIR, as no investigation was contemplated, the approach was made to this court by filing a writ petition. It appears from the record that the contemplation to initiate a proceeding at the behest of the respondent number 1, being an assignee of the UBI, the appellant, in order to protect the ancestral property, deposited a sum of rupees 1 crore 40 lakhs.
21. 1 crore 21.
1 crore 21 lakhs.
And 25 lakhs in cash.
1 crore 21. So in total, say as
46. 1 crore 46.
1 crore 46 lakhs. When the writ petition came before us, before the division bench of this court, the aforesaid fact was disclosed, and after noticing that a serious fraud has been committed, the direction was passed upon the police administration to investigate the issue. They to investigate the issue as disclosed in the FIR filed by the appellant, and simultaneously a liberty was granted to the appellant to file a suit for recovery of the amount which was deposited with the respondent number 1. Full stop. Our attention is drawn to the final report submitted by the investigating officer, wherein it is categorically held that the deed submitted with the UBI is forged and fabricated. But astonishingly, the case was dropped as the identity of the persons being a beneficiary of a loan amount from the said bank could not be traced out. The moment the investigator arrived at the conclusion that the deed relied upon by the bank within bracket UBI is forged and fabricated, the present suit was filed for realization of the amount which was deposited with the respondent number 1 as assignee of the UBI. Such being the startling facts revealed from the record of the instant case, we do not find any justification in the stand of the commercial court judge that no interim protection can be granted at ex parte stage until the defendants disclose their stand. In other words, it is held that the provisions contained in Order 38 of the court is drastic in nature, and therefore the court should not be swayed by the ipse dixit filed by the plaintiff, unless the defense is disclosed by the contesting defendant. There is no quarrel to the proposition that the provisions contained in Order 38 of the court shall be is extraordinary and to be exercised in an exceptional circumstances, more particularly at the ex parte stage. It does not take away the right of the court in a deserving case to pass an order protecting the parties if the circumstances warrant so. The investigation revealed that the deed deposited with the bank within bracket UBI is forced, and a fraud has been committed upon the bank. Yet the appellant who have shown their bona fide in depositing a sum of rupees 1,46 lakhs to protect the said residential house is deprived of the said amount when admittedly they have no role to play in commission of such fraud or the forgery. It has been categorically averred in the said application that the respondent number 1 being an assignee of the UBI, only to extend the financial assistance does not have a requisite amount, as all the fixed deposits have been charged with the bank in order to secure the overdraft facilities. Such being the fact, the disclosure of the assets, or to put a security, would not be construed to be an adequate remedy required at this stage. Equally, we cannot overlook the fact that the protection of an amount is also required in view of the facts disclosed herein above. There is no fetter on the part of the court to convert an application under Order 38 into an application under Order 39, vice versa, provided the ingredients required for considerations are pleaded therein. However, in the instant case, we found that alternatively an order of injunction was sought so that the amount which is lying in the hand of the respondent number 1 may not be dissipated, nor be dealt with pending a final adjudication. We therefore find a strong prima facie case for an order of injunction is made out, and therefore we direct that the amount lying in an draft facilities, overdraft facilities, or what is that?
Overdraft account.
Overdraft
Account.
the amount in the overdraft account. Description has been given,
Yes, my lord.
being
Account number 50200056041810.
Page 42.
Page 42.
with
HDFC Bank.
branch
Branch to nahi? Oh, Parel branch, Mumbai.
to the extent of 1,46 lakhs. Is required to be protected. Accordingly, the respondent number 1 is restrained from using, withdrawing, and or dealing with any money lying in the aforesaid account to the extent of 1,46 lakhs, which shall remain intact in the said account for a period of 8 weeks from date or until further order, whichever is earlier. For the purpose of clarity, it is made clear that
8 weeks from date to কত হচ্ছে? আজকে কত তারিখ?
any amount in excess of the said sum of rupees 1,46,000, 1,46 lakhs can be dealt with and or utilized by the respondent number 1 from the said account. Stop. The concerned bank is directed to take note of the order of injunction passed therein and shall do accordingly and shall act accordingly. The appellant is directed to serve the copy of the instant application upon the respondents by registered post in course of this day, and shall file the affidavit of service on the returnable date. The application is made returnable after 3 weeks.
No, all the respondents. But there are 4 or 5 respondents. Can we serve in the course of tomorrow? On one, we will serve today itself. Post. But we will have to get Xerox of so many copies done.
We have said application, do it.
Only one thing, Madam.
Your advocate and record has a very good machinery. They can do it.
But maybe have a leave also to serve the bank the order of your lordship.
We have said the respondents.
Responded with the petition.
Bank is also there. SDFC Bank is not there. We have said you communicate to it.
Oblige.
The liberty is granted to communicate this order to the said bank.
Said. Oblige. Wait.
Where I have said the bank will act accordingly. Liberty is granted to communicate this order to the bank.
Oblige.
Do it in course of this day.
Yes.
Yes.
Item number 5.
Mr. Shah, Mr. Shah told to keep this matter on Tuesday.
This is the first 5 matter, madam.
My lord, on the last occasion when it was taken up, Mr. Saha had indicated that this week he's in some personal difficulties, not here today, my lord. And it was
Today,
fixed
not
early
today.
on Friday and on Monday, my lord.
Not today.
Tuesday.
Much obliged.
Grateful, your lordship.
6.
Grateful, my lord.
6.
I appear for the appellate.
This is appeal from the decree, my lord.
Decree for?
This is money suit, my lord.
I appear for the respondent.
You have secured.
That amount has been secured. My difficulty is, my lord, last occasion, my learned senior friend said that whether I will argue on the point of jurisdiction or all entire points. My specific instruction is from the company is to argue all the points, my lord.
Yes.
So there is, but I
On
heard,
previous occasion, before a different bench, that submission had been made on their behalf. That is why I was audacious enough to ask that. My learned friend.
Where is that order?
No, there is no order.
So
The learned counsel at that stage who was appearing said that I will only be urging the point of jurisdiction. There was no formal order. That is why I asked my learned friend.
Now-
Let my learned friend proceed in his way.
no, that's true. Let him
now,
argue
my
full,
lord, my lord, difficulty, my lord,
full argue.
if there, the lower
Oh,
court
no.
record is not here, my lord. If
What?
lower court records, my lord.
Why?
If my lord so directs, I can raise the special messenger court and bring the lower court record.
What is the necessity of the lower court record?
This
I
is a
just
money
want to
suit
know.
wherein there was a marine insurance policy taken by the plaintiff against from the company, from the defendant, my lord. Now they are claiming a compensation for the loss happened to them. Now they in the main claim money suit, my lord, the cover note was there, my lord.
So you have included in the paper book.
All papers were not, because there were
Why?
two paper books were prepared the time, my lord. One at our instance, other at the instance of my lord senior.
So that includes all the papers.
Now, since the lower court record is not here, my lord, I will be praying, my lord, if the lower court record be called here,
Why should we call it after? This is 2002.
my lord, I can understand. If my lord so desires, then I have to proceed without the lower court record.
We'll see if there is any discrepancy, if there is any issue which is raised which requires an original document to be looked into, we'll definitely see to it.
My
But well, there is a specific order that is on 16/2/2015, passed by the coordinate bench. It has said, while considering the application for stay, we are of the view that since the fate of this appeal is dependent upon our decision on a particular issue relating to the jurisdiction of the learned trial judge to entertain the said suit due to lack of territorial jurisdiction, we propose to decide this appeal even in absence of the lower court record. And then the court says that you prepare, that is.
There was two paper books, one my lord.
Yes.
One filed at my instance, another was filed at their instance, my lord. If my lord kindly takes up my paper book, my lord, may I place the judgment of the book need?
So nowadays, you being a senior, do not care to read or go through the files and then come and argue the matter. So the lower court record has arrived to this court. Notice of arrival of lower court record has been served upon you as far back as on 21st of February 2018. Under Chapter 9 of Rule 12. What do you say lower court record has not? It is here.
But since it was not.
Argue. You
My
did not, may not have been sent.
My-
Argue. If necessary, we will
My-
direct the
my-
department to bring.
Kindly,
But you can't shy away from doing it.
no, I am not taking any adjournment.
Sorry. Lower court record has. But we received 2 files SCR in a one suit number such and such. After the examination, 2 files of LCR, the same is found complete as per the protocols. 2018 তে চলে এসেছে। তারপর notice under rule 12, মানে notice of arrival of lower court record. That has been sent to all media এখানে। Yes. Yes, where is the paper book?
The paper book was filed in the department itself, my lord.
Where is the paper book? I'm asking you, where is the paper book? Why filed? When you filed that paper book? And why the department will not send the file with the paper book?
I have to take instruction from my learned advocate and record when he filed in the department, because that was served them also, my lord. The paperwork was served to them also, my lord.
But I do not find from the we do not find from the noting that the paper book has been filed. When you filed the paper book, tell us. Tell us, sir, you are an appellant. Are you not in a position to say?
I am not in position to say because
Say. And you are arguing a matter.
learned advocate and got filed in the department, my lord, itself, my lord.
Where is the filing number?
Since there's two paper books, one are filed at my instance, another filed at their instance, my lord.
Take down. The appeal is listed for final hearing. It is really unfortunate that while sending the file, the department is not including the paper book as well as the lower court record, which had already arrived to this court. The learned advocate for the appellant submits that the two sets of paper books have been filed in the department, but we does not find any noting in the file in this regard. The superintendent of the first appeal department is directed to give an explanation as to why and appropriate steps be taken against him for dereliction in discharging the duties in not enclosing the paper book as well as the lower court record along with the file when the requisition is sent to them that the court has directed the appeal to be listed for final disposal. Such explanation must reach to this court within 3 days from the date of the communication of this order. The department is directed to immediately send the paper book as well as the lower court record during before the court resumes after recess. Come at 2, we'll hear out. 4 or 5 minutes, I don't think so anything can happen now. Come at 2, argue.
Lordship, item number 7, your lordship. Lordship,
Yes.
that is for stay of an order, your lordship.
No, it is an appeal which is,
Lordship, it's a section 37 appeal, your
oh,
lordship.
this is a section 37 appeal is appeal.
Lordship, the only thing is no order for stay has been passed and
We
the
will finally dispose of the appeal, madam.
lordship, there is a lordship, there has
We
been
will,
some.
what is the necessity? If we dispose of the appeal, then it
Lordship, the
will.
only thing is directions for paper books had been filed, but due to some miscommunication, the paper books have not yet
Then
been.
what can be done,
Lordship,
madam?
in that
What
case,
can be
if
done?
lordship kindly keeps it next week, your lordship will serve the.
My lord, I am appearing for the respondent. Order for filing paper book was passed on 6th of January 2022.
Lordship, it has been.
2022, now
Yes,
more
your
than a
lordship.
year.
Lordship, it is on account
No.
of some.
No.
Lordship,
What, 1 year, more
miscommunication.
than 1 year?
Lordship, we have already prepared. We are almost, lordship kindly allows us this weekend and lordship kindly keeps it next week. Your lordship,
Not today, then it's next Tuesday, come.
I'm extremely grateful, your lordship.
Yes.
Lord, item 2 was passed over. Lord, item 2 was passed over. My learned friend is there on the other side. Now there's a section 5 application. My lord, I was humbly beseeching if your lordship considers that, and thereafter, my lord, we can come back next week, my lord, after hearing the appeal, for hearing of the appeal.
Give the file. Item number 2.
Item 2, my lord, it was passed over.
days.
But may I also file a supplementary affidavit to the section 5 application, which we have already served on my learned friend, my lord? And if my lord is pleased to take up the supplementary affidavit once, my lord, there's a delay of around 2.5 months.
Have you deposited the deficit
Yes.
court fee?
Yes.
Yes. Where is section 5?
No, there's a section 5, no, that would be can 2. Apart from that application, we have also filed
How
a
much?
supplementary
How
affidavit.
much? days
74 days delay. There's an error in the section 5 application regarding the number of days. We have corrected that in the supplementary, apart from, my lord, including certain other grounds, my lord. Your lordship will kindly have a look
What
at
is
the.
what is simpliciter saying that it is corrected? That is not. What is the ground for delay? What is the explanation?
The explanation was, my lord, really, my lord, files were in different departments of the Steel Authority of India. My lord, there was a marketing management department, and thereafter, my lord, where, my lord, the order was initially communicated, and the, my lord, orders, everything were issued from that department. And now from there to, my lord, the legal department, that has taken some time, my lord. And there are, my lord, really voluminous documents, and, my lord, the process was also.
What do you say?
As regards, my lord, the grounds taken in the section 5, my lord, I do not really want to contest it heavily on merits, but there is just one difficulty, as my learned senior said. The section 5 application has been filed for condonation of delay of 63 days.
They have
Yes,
corrected.
I've corrected.
But they have
On
not.
my learned friend pointing out the
Yes,
mistake.
I had, my lord, the correction is also incorrect, your lordship. By my computation, it is 77 days and they have sought for 70. Very well. I shall not stand the
No, this is an application under section 5 of the Limitation Act,
77.
seeking condonation of delay in filing the instant appeal beyond the statutory period provided therefore. Initially, it has been disclosed in the application that there is a delay of 63 days. But by filing a supplementary affidavit, the appellant discloses that there is a delay of 73 days.
74.
4 days. However, the learned advocate for the respondent says that in fact, there is a delay of 77 days. If the computation is made strictly in terms of section 12 of the Limitation Act. Be that as it may, the length of delay is not material. The sufficiency of the cause is. We noticed from the said application that because of the procedural hazards, as the file has to be routed from the respective department to the legal department for the purpose of taking steps to initiate a judicial proceeding. A substantial time has been consumed to stop. We are not unaware of the movement of the movability in the departments when the file takes longer time to move from one table to another. However, we are also conscious of the proposition that the court must encourage the litigation to be decided on merit instead of nipping in bud on the anvil of the limitation. Since a sufficient cause has been shown, we do not find any justification in refusing to condone the delay in filing the instant appeal. Accordingly, the appeal is allowed. The delay in filing the appeal is condoned. The office is directed to regularize the appeal. Let the application being CN1 of 2023 be listed on Tuesday.
Just one indulgence, perhaps it has gone down as the appeal is allowed. But it should be the application. Application.
Application is allowed. Right? No? Application allowed.
I'm so grateful.
I'm grateful to you, Lakshmi.
Grateful. So item 8 we're paying joint payment, we're paying for not today, my lord.
Item number 8, the next matter, man.
Yes, my lord, my lord. Yep.
Grateful, Lordship.
Yes. Yes. এসে গেছে। কি? নোটিং নেই ফাইলে, কোনো ফাইলে নোটিং নেই, কেন সেন্ড ডাউন হয়েছে কোথায় আছে জানি না, দেখি। Yes.
May I place a judgment, my lord? Kindly comes to page 54.
Main paper book or supplementary?
Main paper book, my lord.
Page
54, my lord.
Yes.
May I place the judgment, my lord?
Yes, yes.
This suit coming on for final hearing and so in presence of Shiva Prasad Mukherjee, advocate for the
No,
plaintiff.
start with that High Court form number such and such. Start from there. Come to straight away. The suit is for realization of the money amounting to
55.
33 lakhs.
This is a suit for realization of money amounting of rupees 33 lakhs 97,025. The plaintiff's case in brief is of follows. The plaintiff, Messrs. RR Enterprise, is an importer of chickpeas and other agricultural products. And the defendant, Messrs. Oriental Insurance Company Limited, a subsidiary of General Insurance Company, had carried on business as insurer of all kinds, including marine risk and adventure. The plaintiff entered into a contract with Mrs. Deepak Trading Company of Singapore and Mrs. So for shipment of 125 metric tons of chanas and 150 metric ton of Turkish chickpeas for import to India. And these were to be shipped from the port of Marseille, Turkey to Bombay, India during the April and May 1986. The plaintiff approached the defendant for obtaining marine insurance cover for the said good and made a proposal dated 22nd May 1986, enclosing therewith a check for appropriate amount of premium. The defendant accepted the proposal and agreed to cover the said transit of goods by marine insurance policy. The vessel MV Sea Cloud set sail from the port of Marseille in Turkey on 11th May 1986 on her intended voyage to Bombay. However, on the way, it proceeded to the port of Beirut, Lebanon, allegedly because of or some mechanical fault. On reaching Beirut, MV Sea Cloud transshipped the cargo to MV Rama, which on explosion occurred in the vessel shortly after it smiled from Beirut port and it sank with entire cargo. The plaintiff, on the basis of its valid marine insurance policy in respect of its carriage, preferred its claim against the defendant. following the loss of its cargo and furnish documents in support of its claim. However, defendant through its letter dated 23rd December 1986 wrongfully denied its liability under the marine insurance policy issued by the defendant and leveled false allegation of non-disclosure of materials facts by the plaintiff, which plaintiff denied through its letter dated 23rd December 1986 issued by the defendant and leveled false allegation of non-disclosure of facts of the plaintiff, which plaintiff denied so and so. The plaintiff claims that a defendant owes its value of cargo with interest and other expenses incurred by the plaintiff totally of rupees 33 lakhs 97,025. The plaintiff thus prays for decree for the said sum with interest on its alternative decree for the sum as may be found due and payable to the plaintiff upon inquiry into its claim. Defendant contested the suit by filing written statement. It claims that on or about 27th May 1986, the plaintiff proposed for obtaining insurance policy in respect of the shipment of Turkish chickpeas from the port of Mersin, Turkey to Bombay, and defendant accepted the premium for issue and issued cover note, subject to the stipulation that the goods were to be shipped as per Lloyd's registered equivalent, classed inner liner, not more over 15 years. Plaintiff informed the defendant about the shipment of the goods, and there was no information about the compliance of the said stipulation. However, on inquiry, this defendant ascertained that MV Shipcloud was over 15 years old and was not Lloyd registered or equivalent classed vehicle. The plaintiff thus suppressed these facts, which rendered the insurance contract void. Defendant then advised the plaintiff that the insurance policy could not be issued and the said cover note was cancelled. Defendant sent refund voucher for the refund of the premium paid by the plaintiff. The defendant claims that the plaintiff's claim should have been against the owner of MV Cloud and which issued hills of the heading covering the cargo. And in absence of the said ship owner, the suit is bad for the defective parties. And further, as alleged contract of insurance and the proposal for the insurance coverage took place at Bombay, the suit is not within the territorial jurisdiction of this court. The defendant thus prays for dismissal of the suit. On the basis of respective submission of the parties, following issues were framed. 1. Has the plaintiff any cause of action? Is the suit maintainable? Is the claim of the plaintiff barred by the law of limitation? Is the plaintiff entitled to get decree as prayed for? 2. What other reliefs or reliefs, if any, the plaintiff is entitled? Whether the court has territorial jurisdiction on to try the suit, and following additional issues were formed during the judgment. There was a contract of marine insurance as between the plaintiff and the defendant? If so, did the said contract cover the shipment of vessels which was not registered with the Lloyds and was more than 15 years in age? Did the plaintiff have any insurable interest in the cargo concerned which was shipped per se MV Sea Cloud? Did the plaintiff suffer any loss or damage? If so, to what extent? Is the plaintiff entitled to recover the same from the defendant? What is the effect, if any, of the plaintiff not having sued the ship owners in respect of the claim, if any, against the ship owners? Is the plaintiff entitled to claim any interest, and if so, to what extent? The evidence on record. The parties have examined one witness each. PW1 Sanjeev Kumar Singhania is a partner of the plaintiff concerned, which is a registered partnership firm. He says that two companies, one based in Mersin, Turkey, other at Singapore, with whom the plaintiff had contract, delivered a total of 275 metric tons of chickpeas to the ship MV Sea Cloud at seaport of Mersin, Turkey, sometimes from 8th to 10th May 1986. The invoice of the two companies were marked Exhibit 1 series. He also renders original bills of lading issued by the shipping company against the Mercedes. On or about 20th May 1986, the plaintiff approached the agent of the defendant company and paid premium, including the overage premium, which the defendant accepted acknowledgement by issuing receipt, Exhibit 2. The payment was made in anticipation of getting policy number. He, that is PW1, claims that the defendant company was aware that that the goods were shipped in MB Cloud, and it accepted the risk of insurance for carriage of the goods, and there was a valid contract between the parties for the particular voyage. Defendant was given correct information which satisfied it. MV Cloud developed mechanical problems and sought shelter at Beirut Port, Lebanon, where the goods were transited to MV Rama, which sank soon after sailing from Beirut. The goods were completely lost. Plaintiff issued power of attorney to the advocate nominated by the defendant. The plaintiff furnished all the required papers to the defendant for the loss of the cargo, and the defendant cannot disown the existence of valid marine insurance policy. The plaintiff's total claim is about 34 lakhs. The plaintiff did not suppress anything from the defendant and did not receive from the defendant any letter stating that the policy could not be issued or any refund voucher from the premium. The General Insurance Corporation fixed the premium for the insurance. The defendant company took overage premium as per the calculation of GIC. He proves document of inter-party correspondence relating to the matter in the suit, which were maintained in their office in their usual course of business transaction, and directed that these were manufactured documents. He also proved copy of the letter dated 11/6/1986 written by the plaintiff by the defendant, signed by him, and the postal registration receipt for the dispatch to the defendant. PW1 further proves the copies of the letter dated so and so, written by the plaintiff concerned to the defendant company, which are marked as Exhibit 5 to 11. He claims that the defendant, who supposed to know that MVC Cloud was more than 15 years old, but he is not sure that the defendant know it. He does not know who are the owner of MVC Cloud and does not the exact date whom the cargo was transcribed to MV Rama, and thus transcript was communicated to him. He does not know whether the vessels were more than 15 years old or not recorded in the Lloyd's Book of Register. The plaintiff lodged a claim against the owner of MVC Cloud, though to such paper has been filed in the court, but no claim was lodged against the owner of MV Rama. He denied the defendant company did not accept overage premium and did not accept the risk of insurance for the carriage of the goods, or that there was no valid contract between the parties. He further denies that the defendant company was not given correct description of the goods, or that is not satisfied with the information supplied. DW1 Shubhro Shankar Chakraborty is an employee of the defendant company. He says that the plaintiff company had made a proposal for marine policy, but the accident took place before the insurance coverage from the insurer company, in which the insurance company is not liable to pay compensation. He says that initially the cargo was shipped from MV Cloud, but as it developed mechanical problems, it had to be transited another ship which suffered the explosion. The defendant is not liable to pay the claimed amount because the insurance policy does not cover that. He says that another suit was filed in the Hon'ble High Court, Calcutta, in connection with the said accident. Mr. so and so and adduced evidence in that suit on behalf of the insurance company. Certified copy of the judgment is marked at Exhibit A. During cross-examination, he admits that there was a contract between the parties regarding insurance, and the defendant had allotted policy number to the plaintiff, which was paid, which has paid the premium. Plaintiff had furnished in the proposal the insurance particulars of the cargo, name of the vessel, and the port of origin or termination. And the defendant accepted the proposal and also accepted overage premium. He clarifies that if the vessel is more than 15 years old, overage premium can be charged. He identifies Exhibit 2 as the original money received guaranteed by the defendant to the plaintiff and state that it is includes the overage premium. He admits that the defendant company agreed to cover the transit of the goods by the issuance of the marine insurance policy, but denies to accept the risk of the insurance. Regarding the carriage of the goods from where the house of Turkey to the warehouse of Bombay, he identifies letter number dated so and so that plaintiff's intimation of claim about the letter dated. So that is the plaintiff's intimation of the claim about the cargo wherein the defendant requested the plaintiff to appoint a constituted attorney at Beirut and the plaintiff appointed an advocate at Beirut. He identifies an intimation Exhibit 3G sent to the defendant of the plaintiff, which states that the power of attorney was to be sent to the defendant for transmission to Beirut, but he does not know whether the plaintiff executed power of attorney in favor of the advocate at Beirut or if the power of attorney was with them. He claims that no cover note was issued to the plaintiff and admits that the defendant is still holding the premium paid by the plaintiff, but he does not know whether the defendant has refunded the money to the plaintiff. He claims that the money receipt Exhibit 2 are issued without any stipulation and that the defendant repudiated the contract through a letter dated so and so. After getting the plaintiff's proposal, the defendant imputed terms and conditions and accepted the insurance coverage as per the terms and conditions. Defendant has not filed any document to show the proper disclosure of material facts not given by the plaintiff and denies that the plaintiff had given the defendant all such information when taking the insurance policy. He has no document to show that the defendant wrote to the plaintiff asking better particulars and information. He admits that the cargo of the plaintiff was insured, but denies that there is no stipulation before granting coverage, although he has produced no documents about such stipulation. He identifies a letter dated 4th December 1989 of the defendant's office, which shows that even after 3 years, the plaintiff's claim was under consideration of the defendant. He also identifies some other correspondence, Exhibit 3 series, issued by the defendant to the plaintiff, and admits that the defendant, though through one of these letters, Exhibit 36, had asked for the plaintiff to execute power of attorney in favor of the advocate of the defendant's claim, settling in the agent at Beirut, and the plaintiff had compared to it. He also identifies the defendant company's proposal form Exhibit B and the form prepared by defendant company for requisition declaration for marine insurance policy, though he has no document to that effect. He acknowledges and issues labor and for the applicable of marine insurance policy. It is applicable in this policy, and the defendant was aware prior to 23rd December 1986 about the loss of the cargo. He denies that the plaintiff company had given the defendant all the information relating to coverage of cargo and insurance. He admits that in the written statement, it was not mentioned that it is an accident occurred before granting insurance policy. In that event, defendant company is not bound to pay compensation. He identifies two conditions dated so and so of the daily shipping times, Exhibit 8 and 8A, a few letters of the shipping industry which are sent of MV seeks out. He also identifies a letter issued by so and so situated at London of the National Insurance Company. He denies that the plaintiff company is entitled to get claim paid for. This is all about the relevant evidence on record. Decision issue number 2. This issue is not agitated by the learned advocate either side for argument, hence it is answered in affirmative in favor of the plaintiff. Issue 1 and additional issue 7, 8, 9. These issues are closely interlinked and are taken up together for the sake of convenience and brevity. There is hardly any need of emphasis that these are the core issues which will decide the fate of the suit. During evidence, DW1 Shubhro Shankar Chakraborty said that the plaintiff had made a proposal for marine policy, but the accident took before taking the insurance coverage from the insurance company, in which case the insurance company is not liable to pay compensation. He also said that initially the cargo was shipped through MV Shipyard, but it developed mechanical problems, but it was transferred to another ship which suffered explosion. The defendant is not liable to pay the claimed amount because the insurance policy does not cover that. He has produced a certified copy of the judgment, Exhibit A, of another suit filed at the Hon'ble High Court at Calcutta in connection with the said accident by so and so, and adduced evidence in that so on behalf of the insurance company. Learned lawyer of the defendant has presently heavily on that judgment and pointed out that the said suit, being suit number so at High Court at Calcutta, was dismissed. On 18/7/2000, the defendant filed a Xerox copy of the judgment dated so and so at the High Court, whereby appeal was preferred by so and so against the judgment, and it was also dismissed. During argument, he has pointed out that the suit number so and so, Mr. So and so had made a similar claim against the defendant Oriental Insurance Company, which was also defended in this suit for a cargo of chickpeas imported from Turkey. But he stressed that the said judgment of the Honorable is practically the defense of the defendant. However, learned advocate for the plaintiff has been quick to point of difference to the fact the suit number so and so and this court. In suit number so and so, the Honorable Court observed that the bills of landing have been endorsed by the shipper of Turkey in favor of the Bank of Turkey, which in turn endorsed in favor of so and so, which is a banker of the Singapore seller or that of the plaintiff. The said bank forwarded the document drawn from the Singapore party, who was plaintiff's seller, along with the bills of lending, though the said banker of the Singapore company of the plaintiff for presentation to Bank of India. The Bank of India did not present the document on behalf of the Singapore seller to the plaintiff, and same had not been accepted on presentation by the plaintiff, nor paid for, not the bills of ending endorsed in favor of the plaintiff. The result was that the Bank of India continued to hold the bill of exchange and the bill of landing for the accounts of the Habib Bank, who in turn were the bankers of the Singapore seller of the plaintiff. Pursuant to such observation, the Honorable Court further observed it is inconceivable that a person who had not obtained the possession of the bills of landing by endorsement thereon and who had not paid for the goods can be said to have got the insurable interest in the goods, and concluded that the plaintiff, Mr. So and so, had no insurable interest in the goods. However, the additional issue number 8 is not deemed to be answered in the way in this suit, nor reasons which will be spelled out shortly. The plaintiff in this suit produced all the 3 original bills of landing, Exhibit so and so, and also 3 invoices in its name, which convincingly proved that the plaintiff paid for the cargo to its owner. Now, coming to the conclusion whether there was a contract of marine insurance between the parties, it is essentially to stipulate that all the 3 very threshold the discussions that the defendant stands in these regards are taken in this WS is contradictory to the evidence of DW1 himself. In the written statement, the defendant had claimed that the plaintiff had proposed for obtaining marine insurance policy, and the defendant accepted the premium and issued cover note subject to stipulation that the goods were to be shipped as per the Lloyd's register or equivalent class in a vessel, not over 15 years. The defendant has also claimed that though the plaintiff informed the defendant about the shipment of the goods, yet there was no information about the compliance of the stipulation. And on inquiry, defendant ascertained that MV Sea Cloud was over 15 years old and not a Lloyd registered or equivalent class vessel, which the plaintiff has suppressed and which rendered the insurance contract valid. Whereupon the defendant advised the plaintiff that the insurance policy could not be issued. The cover note was cancelled. The defendant has even claimed that it sent refund voucher for refund of the premium paid by the plaintiffs. However, during the evidence, DW1 has clearly admitted that there was a contract between the parties regarding the insurance. The defendant had allotted policy number to the plaintiff, which had paid the premium, and he had been even claimed for that the defendant could file the said policy in the court. DW1 also said that the plaintiff had made the proposal of insurance on 22nd May 1986 and not on 27 May 1986. And in the said proposal, plaintiff furnished the particulars of the articles and quantity of goods and the name of the vessel and the port of origin and port of termination. The defendant accepted the proposal. He has also stated that that the age of the vessel is more than 15 years, in that even overage premium can be charged. And he has acknowledged that the defendant, while accepting the proposal of the plaintiff, accepted overage premium, which is included in the original money received granted by the defendant to the plaintiff. That is Exhibit 2. He has further admitted that the defendant agreed to cover the transit of the goods by issuance of marine insurance policy, but no cover note was issued by the plaintiff. The defendant still holding the premium paid by the plaintiff, though he does not know whether the defendant has refunded the money to the plaintiff. He has even sent the money receipt was issued without any stipulation, while claiming that plaintiff accepted the insurance coverage as per the terms and condition. Though he has not filed any documents to show that there was terms and condition which the defendant imposed on the plaintiff, or to show that a proper disclosure of the material facts were not given, or to show the defendant sent any letter to the plaintiff requesting for better particulars. Again, he had acknowledged that the cargo of the plaintiff was insured. When the cargo of the plaintiff was lost, they lodged a claim with the defendant. Thus, from the evidence of DW1, it is established beyond doubt that the defendant had issued an insurance policy to the plaintiff after accepting the overage premium for shipment in question. There can accordingly be no question that the plaintiff has suppressed from the defendant about any information regarding the age of the ship. It is also well established that the defendant is still holding the premium paid by the plaintiff, and the money receipt was issued without any stipulation. Though DW1 had claimed that the defendant accepted the insurance coverage as per the terms and condition, yet he has not able to file any document to show that these terms and condition, or the defendant asked the plaintiff for better particular, or the proper disclosure of material facts was not given by the plaintiff. The spark of contradiction to the claim in the WS, DW1 unequally admitted that no cover note was issued to the plaintiff. This being the state of affair of question at once, in which document were the terms and conditions stipulated by the defendant for acceptance of insurance coverage spelled out or embodied. As already notified that the money receipt Exhibit 3 contained no such stipulation, and as the cover note was issued at all, the question of the stipulation being embodied, the cover note cannot arise at all. The defendant has not been able to clarify the confusion, and only conclusion is drawn is that the plaintiff made proper disclosure of all material facts regarding the insurance policy being issued to it. In this context, it is essential to note that though the defendant claimed in the WS that on learning that MVC Cloud was more than 15 years old and was not Lloyd registered, it cancelled the cover note and advised the plaintiff that the insurance policy could not be issued. Yet during the evidence of DW1 has acknowledged in unequal terms and even as late on 4th December 1989 that defendant wrote a letter to plaintiff stating of the claim for rupees 8,25,000 and 11 lakhs under the policy number so and so, money receipt number so and so, which was under consideration. Though through another letter dated so and so, the defendant asked.
What is your point? Tell us. We have already gone through the entire judgment. I think only point which you have asked is the only points which you have asked. One is that the insurance policy stipulates that the cargo would be carried in a vessel which should be less than 15 years of age. If the cargo is transported or transmitted in a vessel which is of 15 years of age, then this insurance is not covered. Admittedly, in this case, the cargo from a Turkey started its journey in a vessel which was less than 15 years, which developed the mechanical problems. They were forced to dock or take berth in Beirut. In the Beirut, they shifted the entire cargo to another vessel, which according to you was more than 15 years old, which capsized in a deep sea. An entire cargo evaporates. The only question is whether there was any stipulation. The positive findings of the trial court is that you could not prove there was any stipulation. Rather, the court has proceeded that the receipt which they have shown, that they have paid a premium, that receipt shows that there is an overage premium. And you have clarified that what is the meaning of this overage premium. You said the overage premiums are charged if the cargo is carried in a vessel which is more than 15 years. So if that being the position, you have charged the overage, then you have also included within itself that if it is carried in a more than 15 years old vessel, then it is also covered. Then what remained? You were permitted to disclose the documents. There was an interrogatories which was given to you under order 11 rule 1. You have answered, you did not comply. Rather, you came and wanted to file an amendment of the written statement, could not succeed. Up to High Court, could not. Everything has gone against you. You wanted to take a shelter of the judgment of this court in relation to another person, where his claim was turned down by the High Court. And then you said that his cargo was also carried in the same way, same vessels. So once the High Court has turned down, so they cannot. The distinction has been drawn because there they could not prove, because the stipulation was there, and as they could not satisfy the stipulation, it was terminated then and there. It was not issued. But here you accepted the premium, appropriated the premium, issued the policy.
One thing, my lord, while issuing the premium, the cover note which were exhibited by them, which says that with regard to this vehicle, ship, MVC Cloud, subsequently developed, it transferred to another MV Rama, which was never intimated.
But that is what is, your case is not that. Your case is not that. You have not made out a case like this in the written statement, that it was only covered in relation to a particular vessel. It was not covered in relation to any other vessel.
But
rather, you have accepted the position. You say vessel that was not covered. That was the initial.
Even in their evidence, my lord, subsequent letters, they have never disclosed. In the suit itself, they discloses about the change of shipment. In the letters where claiming compensation,
I am still, there was no stipulation. The court has said there is no stipulation which you could prove. No stipulation which could prove. tell me that the policy, in the policy, there was a stipulation that apart from this vessel, if the cargo is carried in any other vessels, not covered under the insurance. No problem. Nothing has been done from your end. Rather, your witness went against you. He admits everything. What you said in the written statement, he countered it and admits. What more?
The policy was also not exhibited, my lord.
Sir, if there was no dispute that there was a policy issued by you, what more? You could have. You have a counterpart of the policy. You have the second copy of the policy. You could have. You did not take. Rather, you admitted, yes, you issued the policy. There is an existence of a policy. What more?
The only issue is that the change which was happened, which was never.
This is not stipulation. That was never a stipulation. Show us, because that's why the court was, I would say, he was really trying to find out anything from the documents.
Another point is the territorial jurisdiction.
This is the last one I said. So far as the merit part is concerned, the trial court has dealt with. If you say that these findings are perverse, we are ready to accept. If you say that this finding is contrary to the record, we are ready to accept. Territorial jurisdiction, definitely you have raised, and the trial court has also decided it and refused.
The policy was issued in the Bombay office, my lord.
Yes. Then the trial court has held that since it was issued in their office at within the jurisdiction of this court, and they received it here, so that creates a. Then you'll have to distinguish the alchemist judgments. You have to distinguish other judgments of the Supreme Court. Tell us, we have gone through the judgment. Anything you want to say on this? This finding is perverse, this finding is wrong, contrary to record, contrary to the evidence, contrary to documents which were exhibited. No problem. We are ready to hear you.
Unfortunately, the policy was never exhibited in the court.
Did you challenge that there was no policy issued? Rather, in the interrogatories, you were directed to do so. You have failed.
The cover note specifies that particular ship, but in subsequent that change which happened,
no.
Even they have not proved that the ship that was on basis of publication of paper, my lord, it came to a conclusion. But no evidence was taken.
Taken up that plea in your written statement. Can you make out a case for the first time? This is a factual aspect from at the bar. What you took in the written statement?
The public insurance company, it happened, my lord.
So would you say that the law would be different in case of a public company and in the case of a private company, or in case of an individual? There is a separate law in the country prevalent, applicable to a different types of organizations. Public sector company, different law of evidence does not apply. Law of contract does not apply. And in case of individuals, yes, rigor. Show us. If the law is one, it is applicable to all. You can't have a immunity.
May I place the written statement once?
I am ready. You were reading the judgment. We said we have already read the judgment. This is the sum and substance. Now, again, I am inviting you. Tell us where the judgment is wrong. No difficulty. We are ready to accept. We are ready to hear you. Show us that what case you made out.
The kindly comes to the written statement.
Yes. Tell us that which portion the judge has gone wrong. Show us.
Page 17, my lord.
Yes, we know. Tell us which portion. Look at your paragraph 5, sir. Very specific defense. Again, I say your defense was 15 years old vessel. That's your case. You have not made out a case of non-disclosure of the another vessel. And these are the exigencies. Yes. Show us anywhere you have said. Even a paragraph 7, you have not said so.
Kindly comes to paragraph 10, my lord.
Yes, that's a fact you have said. Because they disclosed it.
While
That's
making
a fact.
But
Have you taken that plea?
while applying for the claim amount, they have never intimated that also. It's a first time they have came to here in this photo itself. While
What?
making the for the
Sir,
loss.
this is what you say, that the plaintiff has alleged these facts. This is what you said.
Further one point, the insurance policy was taken subsequently. Before that, the date
No,
was
the premium was paid earlier.
but that date was never mentioned.
It is mentioned. It is mentioned, sir. I have seen from the evidence, because there's a unique way of writing a judgment, because he has scanned the evidence first and then answered the issues. Sir, essentially the question of fact, you'll have to take it in your pleading. Otherwise, you can't take it something which is not there. And for the first time at the bar. Other in your evidence, as I say, the evidence is very important because your own witness has admitted everything. Yes. What is the point? Tell us. No, you're not supposed to just read the judgment and then say.
These are the points, my only the 3 points, my lord.
Show us. Build your point. Argue on that point.
If I kindly fix another date, my lord.
Then what we were doing for so long?
So that
Is it not a sheer wastage of time?
those points.
That you are ready with the hearing, and then when we ask you a question that these are the question points, argue, you say another day. Then what for we started the hearing?
Kindly comes to the supplementary paper book once, my lord. Kindly comes to supplementary paper book.
Oh, yes, we can.
Page 81, my lord.
Yes.
The evidence of the partner, my lord. That is at page 82, last portion, my lord. In MVC cloud, the goods were loaded on or about 8 to 10th May 1986. These were the original bills of landing issued by the shipping company in so and so, showing the goods have been loaded on board on the vessel. The name vessel was mentioned in the bills of landing. She received by me through our banker. It remains in custody of official courts of business on or about 20th May 1986. They approached the agent of the insurance company.
Yes.
So it's much later, my lord.
You accepted the money, you issued the insurance certificate, everything has been issued and admitted by you.
It was a subsequent, my lord. The policy should be taken before that.
You accepted the money. You encashed the check.
Kindly comes to 85 also, my lord. The vessel seeker out got a mechanical defect and seek nearest port of shelter at Beirut. Subsequently, goods were transferred to MV Rama. Upon sailing the Beirut and after same, the goods were total. No date was mentioned when the accident took place, my lord.
Yes. Yes.
If the goods were sank, they have to satisfy that when that happened.
Yes.
Kindly comes to 87 also, my lord. The vessel, the sea cloud did not deviate from its route. There was a mechanical trouble of the sea cloud. As such, it had to seek near shelter. The owner of the sea cloud, after knowing that vessel cannot reach because of mechanical transfer, yes, it took the action from the MV Sea Cloud. But no date is mentioned. When did the goods were transferred from this ship to another? The policy was to a particular ship. They have given that document, my lord.
Yes.
Kindly comes to their letter. Page 180. 173, my lord. It was on 5th of August, 1989. They are saying about subsequently of the loss of that vehicle. They have not also disclosed that fact. That goods were transferred from one ship to another. So these are my points. My lord.
That's all.
The goods were transferred. They never informed the insurance company about that fact, my lord. And
your witness says that I was aware from a shipment that I do not know that newspaper where all news are uploaded. You are aware everything, and those were marked on exhibits. You showed that, and you say that you were not aware till that is closed. Very interesting, sir. You produce certain documents in cross-examination. They admitted it. Yes, let it go. And you say when the incident occurred, you are aware. When the ship capsized, you are aware.
But that date, even in the cross-examination, they also stated the date when the ship was.
You in your cross-examination accepted it. Should I invite you to that portion? And you are arguing. I am inviting your attention. Come to page 109. Line about 1, 2, 3, 4, 5. From the top. The sentence begins, I have mentioned that if this accident occurs before granting insurance policy, in that event, our company is not bound to pay compensation. Then it is a fact that Daily Shipping Times is a newsletter of the shipping industry. This is the Daily Shipping newspaper of May 1986. It is a fact that the name of the ship Sea Cloud is mentioned in the said newspaper. Marked Exhibit 8 on admission because they said very good. This is another Shipping Times dated 2nd June 1986. That is a date when the incident happened. Marked Exhibit 8. This also speaks about Sea Cloud. So you were all along aware that what has happened.
But the accident was not on the Sea Cloud.
This is what is the incident about Sea Cloud means what? That there was a mechanical problem and they took birth to a particular Beirut. Everything was there.
But this change which happened to another ship, that was never intimated.
We have to look at the Shipping Times, which has been marked Exhibit 8 on admission. This was your document which
So
you
if
produced.
the incident happened to the Sea Cloud, there was no dispute.
Please look at it. Look at it. Exhibit 8 is where the Exhibit 8 is page 180. No, this is not an Exhibit 8. Where is the page? Oh, yes, this is the Daily Fish Shipping Times. Where is that this cloud? Yes, 6 by 6. Yes. Exhibit 8, capital A, page 188 is also. And it is not a disputed one that it never capsized.
Well, Sea Cloud, it's not. The capsize was MV Rama. There's another ship.
Sir. This is how it comes. I am again saying. You have not taken that plea at all in your written statement.
Kindly see, my lord.
Please, that the insurance policy does not stipulate any transfer of the cargo from one ship to another. It never took it. If there is no stipulation, you can't. Anything more?
No.
Yes, thank you. Yes, Mr.
To add after. Well, the judgment, if I may say so with the deepest of respect, is so elaborate and goes into such painstaking detail that it solves a lot of our problems. Everything has gone into in absolute detail.
And the way he's arguing is not there on the record, actually.
Well, it will pass whatever.
It's not on record. You are taking something which is. Yes, Sevi.
Grateful.
পেপার বুকটা ওনার কাছে পাঠিয়ে দাও, উনি পেপার বুকটা দরকার আছে একটা, আমাদের কপিটা একটা থাকুক, আর মেন হচ্ছে মেন ফাইলটা যাবে, মেন ফাইলটা দরকার নাই। জাজমেন্ট দেওয়ার জন্য যেটা আছে সেটা মেইন ফাইলে লোয়ার কোর্ট রেকর্ড চলে এসেছে কিন্তু ফেরত গেছে
I don't know, 9.
Lordship, I'm appearing on behalf of the appellant. Lordship, we have already, so the other party has already shared the draft of memorandum of settlement, and we have also.
But this was with regard to your lordship remembers that Kaun Banega Mukhyamantri, that thing, my lord, as per your lordship's direction, my lord, we had given them the terms long back. Now, like, my lord, 2 days back, my lord, they have given us with their observation, my lord. We'll just speak to our clients once and we'll just.
So let it appear after fortnight because
Yes,
it will
my lord,
take time.
fortnights, yes.
It is submitted by the respective councils that they have exchanged their terms of settlements.
Yes, sir.
Which require some more time to bring some more time to consider the same. So in view of the above, let this appeal be listed after 2 weeks.
Grateful to you, lordship.
Much obliged, your lordship.
Let's call the next matter.
10.
Number 10.
The appellant in this matter. This is that matter your lordship will kindly remember. I'm led by Mr. Shoptangshu Basu. 3010 has been allowed, lordship. Order 3910 has been allowed. Mr. Shaha was appearing on behalf of the opposite party. Lordship has fixed certain matters on next Thursday on the point of 2C7. So can it be heard out on that day?
We don't know why. It's only order 39 rule 10.
No, we have also made the maintainability point. Your lordship has passed in judgment. I have gone through the judgment. Whether the commercial court can entertain a eviction, recovery of possession.
That is a different issue.
Here is also lordship, the suit property involves a hotel business. And lordship, on the basis of a lease agreement, they have served a notice under 106. Lordship will kindly take it up next Monday.
Are you ready with the matter? Straight away sale.
No, let it be adjourned for today.
Not this week.
Number 11.
Matter I appear on behalf of the appellant, your lordship. The paper books had been prepared and supplied to the council for the respondent. My copy for the court is here. Lordship, kindly takes it up next week, your lordship. I need to prepare myself only next week. Next week. Today I'm not really prepared. Any day next week. Thursday,
Naturally,
next
paper book has come.
I'm filing.
What is this? Why 3 sets? Oh, 6.
2 sets, lordship. Next Thursday, your lordship.
2 sets of paper book filed today be kept on record. The copy of the paper book has already been served upon the learned advocate appearing for the respondent. However, accommodation is sought on behalf of the appellant. Let this matter be listed on next Tuesday.
Next Thursday, lordship. Thursday. Next Thursday. I'll be doing the matter. Next Thursday.
But come ready.
I'll be. I'm deeply obliged.
Inner side में तो पुस्तक है।